Continuing line by line consideration of the terminally ill adults end of life bill. Sergeant Joseph.
Thank you, Chair. I think I was stopped at the point talking about the capacity assessments and the training, as we talked many times in this committee, for the people who may carry out capacity assessment. And I was talking with my experience of completing those trainings as part of my professional job and carrying out capacity assessment for the past 22 years. I'd like to take some quote from the oral evidence we heard from Dr. Rachel Clark, who has had an extensive experience in training doctors and nurses in capacity assessment. What she was saying, I would suggest that anybody who pretends that those assessments are easy and routinely done well in the NHS has not got enough experience of observing that happening. I teach capacity assessment to doctors and medical students, and it is often the case that they are very poorly conducted. And with my experience, I would like to say that this is my experience as well. And we also talked about the second doctors. And in the NHS, especially in the mental health sectors, my experience is many of these doctors are not substantive roles, and many locum doctors work in these many areas. And I'm not confident, and with my experience as well, these trainings are being taken up by many of the people who are working in the NHS. I don't think any of the trusts will be able to evidence that they have 100% training for their mandatory training. Especially for the locum doctors, there's no system of monitoring this by the trust. So I'm not confident that this training will be something that will be robust enough to support some of the claims. Thank you.
I'm grateful, Chairman, and I completely agree with what he's saying about the importance of getting the training right, but even if the training were right, it might not be robust enough. Does he also agree with me, because the point was made earlier in the debate, that there is a clause towards the end of the bill around codes of practice which specify that medical professionals must have regard for a code of practice which may be set out by the Secretary of State. Does he agree with me that this is a very thin defence to rely on? We're not talking about anything that's in primary legislation or secondary legislation. It'll be in a code of practice which may be laid down by the Secretary of State with no obligation, no legal liability for a doctor not to follow it. So we're talking about some layers down from what needs to be on the face of the bill in terms of the assessments that should be conducted.
I thank the member for his intervention, and I agree. Yes, as part of the code of practice, the professionals are expected to complete those training that's been outlined already. But what I'm saying is I'm not confident that is actually happening, and it's not reassuring me to say that there will be training so that this will be robust enough.
Would you give way on that point?
I'm happy to give way.
Thank you, Chair. And further to comment from my honourable friend, the member for East Wiltshire. Is he reassured by the fact that there will be training in the bill? It's actually on the face of the bill, therefore it will definitely take place. And
we address the Chair, please, not.
And Chair, to the point the honourable member across the way made, I'm pretty confident if it isn't already down, there is an amendment going down which will make that may to a must in terms of code of practice.
Sergeant Joseph.
And thank you for the intervention. And I would be, I'll be happy to see that if we have this bill make a strong case that those people who are going to take part in this process have the training before they do that. But my larger issue was around the independent doctors, and I use some of the examples of how the Mental Health Act being carried out in the current format in the country is they always use a Section 12 approved doctors who is a second doctor, who may not have any kind of contact with the patients. So we may not end up in that sort of similar situation. That's the point I was making earlier. the point I just want to raise as well, like the Royal College of Psychiatrists mentioned, the capacity can change, and also the decisions are opinions with the margins of error. Like I earlier mentioned, my experience in working in the mental health wards, and also the Honourable Member of East Wiltshire talked about capacity assessments carried out when patients are standing by the bridge or threatening to jump off the bridge. I'm not comparing those two are in a similar situation here, but I have seen that we have to make those decisions based on the capacity. So my own experience of discharging people from a hospital in a mental health unit, when somebody is threatening, I'm going to kill myself if you discharge me, the multidisciplinary team there, the doctors, the nurses have to make the decision whether they're going to discharge the patient based on their capacity at that time. So those capacities are assessed based on whether they are able to understand the information, can they retain, can they use and weigh it, and they communicate their decision. So it's based on that. But we cannot compare that with this, in this situation of somebody asking for an assisted dying. So this is a point I just want to make clear, that the capacity assessment is the key. So I would love to see and support these amendments. And as I said earlier, this is one of the reasons I voted against this bill during the second reading. And by supporting this amendment, that may change my position. So I would love to support this amendment. Thank you.
Jack Abbott.
Thank you very much, Chair, and it's a pleasure to serve under your chairship this afternoon. I'm speaking specifically to Amendment 50 that's been proposed this afternoon. And first can I say I fully appreciate and accept my honourable friend Stroud's points that he's made on a number of occasions during this debate, which is that many of the items in here are either featured in the bill in certain places or is a current course of practice when it comes to doctors and other medical professions. And as I've said previously in this committee, I'm not generally in the business of supporting amendments which, in my view, occasionally overcomplicate issues, are ambiguous and could lead to other consequences, or are simply a case of repetition. I have to say, though, in this particular case, I don't think this particular amendment does that. I think certainly some of the things, as I've already said, are featured in the bill, either directly or implicitly, but I do not see currently how this particular amendment is written, where it would, as I say, fall under those things which may be overcomplicating or lead to ambiguity. I think these are quite direct, dare I say, common sense asks that I think we should all support. I take the honourable member's point from North West Hampshire around section F. I must confess I didn't read it like in the same way the honourable member did. In my view, I read this as, and I think this is a sensible suggestion, that anyone looking to go down this route are made aware of the consequences from a legal point of view. I don't expect a doctor would be going into people's bank accounts or understanding deeply their legal affairs, but I think that due consideration and advice and information should be imparted on the person who is applying for this. That is certainly how I read it. I didn't think it would be a hugely intrusive, in-depth study into a person's personal finances.
Would you give way on that point?
Absolutely.
Thank you, Chair. Would you acknowledge that that could then be a problem if we've got two members who've read an amendment and actually got
Will
a
you
different
address the Chair, please?
this way, and have got a different interpretation, then that is potentially an area of concern, Chair.
Jack Abbott.
Quite potentially. I think absolutely everyone, as has been the case throughout this entire committee process, or going on the 16th hour now, there are certain words and there are certain clauses where we'll come to very, very different conclusions. It's already been said that this could potentially be tightened up, and welcome our honourable friends from the government in kind of understanding their position here in aspects like that. But in my view, I don't think there's anything specifically which would say this would be an intrusive look at someone's personal finances. I think this is proportionate in terms of the advice that would have to be given. And yes, in terms of Section B, I think it could be very reasonably argued that has already been covered under things, as we've discussed extensively, such as coercive control and pressure. I think Section B certainly comes under that. But I don't equally think that any of the language within this text would necessarily overrule any of those issues or make it more ambiguous. And from that point of view, I think I will be supporting this amendment. I don't think there's anything in here which would override or lead complications for any other part of the bill. But what it does do is put in black and white on the face of the bill some of the very basic processes that should be happening in this. And I appreciate, as I've said to sum up, that many of these things are already happening or feature directly or implicitly in the bill. However, I don't think there is any harm, in fact, given what the nature of what we're talking about, given the fact it's unprecedented in this country, we should be very clear and direct. I don't think it will lead to confusion for our medical profession. I think these are very straightforward, as I say, common sense sort of asks. So on that basis, Chair, I'll be supporting this amendment today. Thank you.
Lewis Atkinson.
Thank you, Chair. I'll speak very briefly. I wasn't intending to, but I just want to follow my friend, the honourable member from Ipswich. I agree in terms of what is set out in Amendment 50 is entirely sensible, and I support the provisions. However, I won't be voting for that amendment, and I just want to explain why. The regulation of medical practice in this country, I think we go down a very difficult route. If for every individual area of medical practice we set out on primary legislation, we have not got an equivalent version of this for how doctors should talk to their cancer patient and what information they should give. We haven't got the equivalent in various other sensitive acts, the Abortion Act, the Human Fertilisation Embryology Act, etc. And the reason for that is that we rely, as set out in statute, on regulation through the General Medical Council. Now, I just do want to read into the record some of the existing General Medical Council outline, which says, so this is to doctors, the information you give to patients, and of course this covers any doctor-patient interaction, and it would apply in this case as well. The information you give to patients, you must give patients the information they want or need to make a decision. This will usually involve diagnosis and prognosis, uncertainties about the diagnosis or prognosis, including options for future investigation, options for treating or managing the condition, including the option to take no action, the nature of each option, what would be involved, and the desired outcome, the potential benefits, risks of harm, uncertainties about, and likelihood of success of each option, including the option to take no action. That is already set out under by the General Medical Council. I will.
Danny Kruger.
I'm very grateful. He makes an important point about the obligations on doctors to communicate the range of options that that patients have, and we're going to come on in the next clause to discussion of that more precisely. But his suggestion that this should be treated just like any other medical treatment is surely contradicted by clause 4.1, which specifically disapplies the Montgomery ruling, which I think he's actually relying on there, which specifies that doctors must communicate all available options to patients. In clause 4.1, the doctor is not obliged to communicate this particular option. So surely does he accept that already in the bill it is acknowledged that assisted dying is not the same as all other medical treatments, does not have to be communicated in the same way?
I will call Lewis Atkinson in a moment. Can I just say, can we please keep interventions as short as possible? Thank you. Lewis Atkinson.
Thank you, Chair. I accept that 4.1 rightly sets out that no medical practitioner is under obligation to raise the subject of assisted dying, but that's not what this amendment, Amendment 50 that I speak to, is about. It's about the information that someone has around the likely effects of taking this course of action, if that was something that a patient would be pursuing. And in that case, it is entirely right that that GMC guidance would apply, as it would with any other procedure, including very sensitive procedures. And of course, the benefit of having properly medical regulation on a statutory footing is that that's able to be updated by the GMC, and that we don't have to update. To answer an issue before that came up in debate about why would it be more complicated, why would it be more burdensome to have some of this set out in primary legislation, is that when doctors can't know they have to relate to the GMC guidance, they are more likely to follow that. If they think, oh, hang on, I need to I need to think about what the guidance is in this bit of primary legislation, where does that stop? Do we start putting in slightly different worded bits of guidance for information about different areas? I'm just going to finish the point, if I may. For different procedures, that is a recipe for absolute confusion and less adherence, in my view. So, yes, I'm happy to.
Giving way. I completely hear everything my honourable friend is saying here, but I think we've also got to accept this isn't like any other sort of legislation we would put forward. This is arguably one of the most seismic societal changes that we're going to be passing as parliamentarians. So, in my view, I don't think this sets a precedent that for all future health legislation we're going to have to set out the clear procedure. I apologise, Chair. I've lost my train of thought. But my essential point, Chair, thank you, was that in my view, this does not set a precedent. We have to recognise that this is an incredibly important piece of legislation, and I think there is absolutely nothing wrong with being absolutely clear and stated amongst the procedures that would have to be undertaken in order to pursue this.
I don't need apologies, I need brevity. I'm not going to repeat myself again.
Thank you, Chair, and I thank my friend for his intervention. We may need to disagree on this point. I think I agree clearly this is a significant landmark legislation that is different to many other forms of treatment, but that is reflected in the safeguards and the provisions elsewhere in the bill. I do not believe it needs to... just let me finish this point, and I'm very happy to take it from my friend. It doesn't need to set out the way in which information is given, in my view. The difference in nature is set out elsewhere in the bill in terms of the safeguards. And I think that in terms of information given, the point of Amendment 50 as drafted is essentially to repeat, in my mind, what is already in place, regulated through the GMC entirely rightly, and we've got much more likelihood of that being adhered to, as we all wish to, if that were not in the case. I'd be happy to...
I thank the Honourable Member for giving way. Would the Honourable Member not agree with me that the purpose of the GMC writing this in detail is for the purpose of treatment, but this Act is not about treatment, so therefore different in its very nature?
Lewis Atkinson.
No, I don't agree with... thank you for your intervention, but no, I don't agree, because the GMC guidance in many ways talks about not accepting treatment, or is equally as useful in withdrawal of treatment situations, in end-of-life situations, etc. So, fundamentally it goes back to the point I think I was making in my speech yesterday around informed decision-making and autonomy of the patient, that has to be informed, whether it is treatment that they're seeking, or whether it is withdrawal of treatment, or whether it's no treatment at all. So that's all I want to say. Yes, of course.
Very good, Honourable Gentleman. I just wanted to reiterate a point that we've made previously, briefly, if I may, Chair, which is about the more we seek to police the conversations between medics and patient, the more guarded those conversations may become by those who, as we know from evidence we've got, are determined that they're going to get an assisted death, whatever. The more we lay it out in black and white, the more people may seek to manage their responses. So, for example, forgive me, Chair, in response to the Honourable Gentleman, if my doctor said to me, well, do you have life insurance, Kit? We need to understand. I may say, well, actually, no, I don't. I may be forced or feel I have to lie to the doctor to get what I want. What we want is an open conversation that is not guarded in that way, and therefore putting this on a bill may produce exactly the opposite that we're trying to achieve.
Lewis Atkinson.
Thanks. I think the Honourable Member makes a good point. So, For the reasons that I've outlined, I won't support Amendment 50, but I would hate it to be characterised, for any of us who don't do that, as disagreeing with the fact that we think relevant available information about care and treatment should be done. We believe I believe, certainly, and I think some colleagues believe, that is best done through existing regulatory routes, primarily through the GMC, and that's why I'm unable to support Amendment 50.
Minister Stephen Kinnock.
Thank you very much, Chairman. It's a pleasure to serve under your chairship this afternoon. As usual, my remarks will focus on the legal and practical impact of amendments to assist members in undertaking consideration of them. This set of amendments seek to change the way in which capacity is determined. As currently drafted, the bill requires that a terminally ill person must have capacity to make a decision to end their own life before they will meet the conditions for accessing assisted dying. Capacity in the bill, as drafted, is determined in accordance with the Mental Capacity Act, which presumes capacity unless it is established to the contrary. Amendment 322 would reverse the presumption of capacity and, in effect, establish a presumption of incapacity. It may be helpful to the committee to set out the government's understanding of both the Mental Health Capacity Act and the implications for this bill. To start with the Mental Capacity Act, it sets out in Section 1 several guiding principles, including that a person must be assumed to have capacity unless it is established that they lack capacity. The Act also, at Section 3, sets out a description of the factors which demonstrate that the person is unable to make a decision for themselves. These are that the person is unable to understand the information relevant to the decision, is unable to retain that information, is unable to use or weigh that information as part of the process of making the decision, or is unable to communicate their decision. This inability must be because of an impairment or disturbance of the functioning of their mind or brain. Turning now to the bill, at each stage of the process, an assessment of capacity would be required. This assessment of capacity, in accordance with the Mental Capacity Act, is separate to the considerations of whether a person held a clear, settled and informed wish to end their own life, which is also required by the bill. This amendment also disapplies Section 1(3) of the Mental Capacity Act, which is the principle that a person would not be treated as lacking capacity unless all practicable steps have been taken to help them make a decision. This could create challenges for practitioners who have experience using the Mental Capacity Act, as they would need to apply this new approach. Amendment 49 seeks to apply a consistent approach to the burden of proof when assessing a terminally ill person's capacity for assisted dying. The Mental Capacity Act has two evidential tests. In court proceedings to determine capacity, the balance of probabilities tests applies. When care or treatment is given to someone on the basis that they lack capacity, there is protection from liability if there is a reasonable belief that the person lacks capacity and that the intervention is in the person's best interest. This amendment would diverge from this evidential approach. It is also likely to have some implications for the workforce, requiring doctors who have experience in applying the reasonable belief test to instead apply a balance of probabilities test for assessing capacity would be likely to have the effect of making the current established approach more complex and potentially less safe. Amendment 50 seeks to specify certain matters that the person must be assessed as being able to understand in order for a determination to be made that they have capacity. Under the Mental Capacity Act, when a capacity assessment is carried out, the assessor must determine the salient information that the person needs to understand, retain and use or weigh based on the circumstances of the case. This amendment would diverge from this approach, both by specifying in statute the information to be understood and by only including the requirement to understand, but not retain, use or weigh. The committee may wish to consider if this, in some respects, weakens the test. This amendment might create two legally distinct frameworks about decision-making that doctors would be expected to use. Again, this may introduce additional complexity to those undertaking these assessments.
Will you give way?
I will.
Danny Kruger.
I'm very grateful. As I understand it, the objection to the amendments is on the basis that it sets up an alternative framework for all other healthcare decisions. Is it his view that assisted dying is a healthcare treatment?
Stephen Kinnock.
I thank the Honourable Member for that intervention. I think we are talking about the holistic nature of engagement between patients and medical specialists. In some cases, that is for treatment, and in some cases, that's for the withdrawal of treatment. So I think the answer to his question is that what we're talking about here in terms of two distinct legal frameworks relates both to treatment and to the withdrawal of treatment, and that this bill fits into that category in the sense that it is part of the engagement and conversation that happens between a patient and a medical practitioner.
Danny Kruger.
I'm grateful. I'm not talking about the withdrawal of treatment, which I recognise is covered under the same legal frameworks, Mental Capacity Act particularly in this case, as other healthcare interventions, because the withdrawal of treatment concerns a healthcare intervention, the withdrawal thereof. My question is it the view of the government that the administration of assisted dying under this bill would be a healthcare treatment?
Stephen Kinnock.
I think it's the view of the government that this is a new piece of legislation that introduces a new type of engagement between somebody who is, and as all set out under Clause 1 of the bill, meets the conditions and the criteria for that, and the engagement that they then have with medical practitioners and other experts as set out in the bill. So I'm not quite sure what he's driving at in terms of whether he wants to get into a discussion about the definition of the word treatment. I think it's absolutely clear that this bill introduces changes into the system and a new part of a conversation that would take place between medical practitioners and patients who have less than 6 months to live.
The Minister give way.
Rebecca Paul.
I thank the Minister for giving way. The Minister there, in giving that explanation, has used the word new several times, and I think that is the crux of the arguments we are making here today. This is a very new approach, new process. So would the Minister agree that it would warrant a different, more robust approach to looking at capacity?
Minister Kinnock.
It's the government's view that even though the nature of this bill is introducing something that is new, introducing new and potentially parallel legal frameworks doesn't improve the clarity or the workability of the legislation. In essence, the government's view is that you bring forward legislation. If that legislation passes, you bring forward regulations. You then bring forward training and capacity building to ensure that ultimately you have a system that is operational. Bringing forward a new parallel framework of legislation at that first step, there's no argument. The government doesn't see the argument that that is actually going to improve the workability and operationalisation of the bill. So my role as a minister on this committee is to talk about the fact that we need to have a bill that is workable, operational and legally watertight, and the general view of the government is the more new additional factors you put into the basic legislative base, if you have a legislative base which in the view of the government works, namely the Mental Capacity Act 2005, don't add more complexity into that first legal base. I will give way.
Mary Titbull.
Thank you. Does the Minister agree with me that, building on the points that my honourable friends opposite have been trying to make, that actually what we're talking about here is the act of disconnecting a respirator, is the reasonable person on the street would believe that was a positive act, and an act which currently the Mental Capacity Act is applied for in relation to decision making, and is therefore analogous to the process that the Mental Capacity Act will be used for in the current legislation that we put forward today.
Well, I thank my honourable friend for that intervention, and I think she makes a very important point, which I think relates to the point, and she made it more eloquently than I could, in terms of the discussion about withdrawal of treatment as being an important part of this conversation. What I would also say is that we fundamentally have to ensure that whilst we totally understand that members want to address certain risks that they see arising from this legislation through primary legislation, it's important to point out that by doing it through primary legislation, you could end up with something that's actually counterproductive, could lead to the bill being less workable and therefore potentially less safe. But that's a balanced judgment.
Sir John Joseph.
Thank you, Chair, and thank you for giving way. Would the Minister agree, withdrawing treatment, especially talking about switching off ventilator, often this decision is made within the medical professionals and the families, and the patient have no say in it most of the time.
Minister Kinnock.
Well, I thank my honourable friend for that intervention. What we're talking about today in terms of this bill, and this bill committee's job is to improve this bill, is a number of safeguards which do ensure that the patient is absolutely consulted and positively and constructively engaged every step of the way. So I think that this is it's different in that sense to the situation that he describes. I bow to his expertise as a medical practitioner in this field. It sounds like that what he's just described is not an ideal situation, but certainly this bill, it would appear has safeguards which ensure that that situation he described should never arise. I will give that.
Thank the Minister for giving way. And just building on the intervention by my honourable friend from Ashford, in most cases where life support machines are switched off, by the very definition people are being supported to stay alive, so they don't necessarily, in most cases I would argue, they don't have the capacity, their capacity is not tested. What I want to ask the Minister, he appears very certain that this wouldn't be workable, but how can the government be so certain in absence of any impact assessments to the workability of this bill in the first instance?
Well, I thank my honourable friend for that intervention. Fundamentally, the balance of judgment about risk is based on whether if you add additional words, phrases, amendments to a piece of legislation, would that have the result of decreasing the risk that you're trying to address or of increasing the risk that you're trying to address? The government's view is that the Mental Capacity Act is a robust foundation for the decisions and the processes that are set out in this bill. Honourable members are, of course, absolutely welcome to say they don't believe that, they don't believe the Mental Capacity Act does do what it should be doing, and that's why they've tabled amendments. But the government's view is that the risk of somehow creating a parallel framework to the Mental Capacity Act would be increased by doing so, rather than keeping it as the foundation that the system is very familiar with, knows how it works. That's the best way to minimise the risks that I think all honourable members are keen to minimise risk to the greatest extent possible.
Will the Minister give way?
Daniel Francis.
Thank you. The Mental Capacity Act Code of Practice outlines that following court judgments, there is a separate capacity for test for making a will, for making a gift, entering into a contract, litigating and entering into a marriage, and outlines in section 4.5 that there are those specific legal tests on top of the mental capacity assessment. So can the Minister therefore outline why we allow low separate mental capacity tests in those cases but not in this case?
I thank the honourable member for that intervention. I think what we're saying here is that we have the Mental Capacity Act as the legal basis for the questions that we're addressing in this bill, but clearly on top of that there will be regulations brought forward by the Secretary of State to ensure that medical practitioners have the adequate training and capacity building takes place so that the system is able to deal with the question before it, and that the judgment, therefore, of the medical practitioner is trusted. And I think in the the situation that he just outlined, that would be the same case. So again, it's the process that every government goes through in pretty much every single aspect of policy that the government deals with. You have a legislative basis, you bring forward regulations, you deliver training, you build capacity, and the system works on that basis. So whichever, then we need to make sure that we have a system that is flexible and robust enough and resilient enough to be able to deliver and address whatever challenges that it faces.
Sorry, can I just come back?
Daniel Francis.
I will read section 4.5 of the Men's Capacity Code of Practice. For certain kinds of complex decisions, including making a will and the others I've just mentioned, there are specific legal tests in addition to the two-stage test for capacity. So that already exists within our law. For other tests, there is an additional test.
Stephen Kenner.
I thank him for that intervention. I see the point that he's making, but I think what these amendments, as the government understands them, would do is that it risks creating a parallel legal framework and increasing levels of uncertainty. And the more you increase levels of uncertainty, the greater the risk becomes of the system not working properly. So clearly, the situation that he describes, I think, is based on particular measures that have been brought forward. But what we're talking about in this bill in terms of what goes in primary legislation is a legal framework, it's not a code of practice. Turning now to Amendment 398. This amendment would remove the existing presumption of capacity in the Mental Capacity Act, thus requiring a capacity assessment in every case. This amendment would also establish a different test for assessing capacity with regards to the decision to seek assisted dying. Establishing a lack of capacity would not be based on an inability to make a decision because of an impairment or disturbance in the functioning of the mind or brain, as in the Mental Capacity Act. Rather, this would allow for consideration of other factors, such as immaturity. It would also apply a higher standard of proof than the Mental Capacity Act requires for other decisions, including for serious medical treatment, by requiring assessors or to establish capacity beyond reasonable doubt. This may raise questions about the nature and extent of the evidence required. In summary, this would introduce a new framework for assessing mental capacity specific to assisted dying. This may create operational challenges for practitioners and healthcare professionals who are well experienced in applying the Mental Capacity Act. Not doing clause 3 stand part now, are we? No, sorry.
It's all in one sentence.
We are doing clause 3 stand part now, right? Okay. I will give it.
Rebecca Paul.
I thank the Minister for explaining that. Does the Minister recognise, however, that essentially what has been said today is that operational reasons are driving the decision that we make with respect to capacity? And does he not think, when we are talking about a decision for someone to end their life, that it would absolutely warrant us doing something that might be slightly more difficult operationally and having that two-tier approach? And would he also recognise that there's a lot of members here that have spoken about our amazing medical practitioners and how capable they are? So surely those amazing medical practitioners could cope with two sets of frameworks.
I thank her for that intervention. I think it goes back to what I was saying earlier, which is fundamentally a judgment call about, do you think you make the system more robust and resilient and effective by adding more complexity to it and bringing in a new and parallel legislative framework, or do you think it's best to work with a legislative framework that is well established, well understood by practitioners, and you then enhance that through regulations and training? It is the government's view that the latter is a more effective way of doing this legislation, but I absolutely accept that honourable members who've tabled these amendments clearly wouldn't agree with that analysis.
Last intervention, I promise, sort of. Maybe. Not ever. In this speech, in this minute. No, just to quickly clarify, there was an amendment tabled by the honourable member for Richmond Park, which would have replaced clause 3 altogether. That would have been understood as a parallel system, which I think would be appropriate, because this is a new order of intervention, which I won't call a medical treatment. But we're not doing that. We're accepting the Mental Capacity Act. It's not a parallel process. It's one that builds on the foundation of the Mental Capacity Act in the way that the Honourable Gentleman described already happens with other respects. It's a question of putting it into legislation or putting it into code of practice. I recognise his arguments, but please really acknowledge that we're proposing actually to build on the Mental Capacity Act and to enhance it in legislation to make it safer.
Minister Kinnock.
Well, I thank him for that last intervention that he'll ever make on me. And the government's analysis of the amendments that have been tabled in this grouping are that, to varying degrees, they don't add to the clarity. They add more complexity, partly because they are either creating a parallel legal framework or putting new elements into the mix of the legal framework that operationally would create challenges for practitioners. That's the government's fundamental analysis on this point, but it's a balanced judgment, and I absolutely accept the argument that he's making.
My understanding is that, perhaps he could correct me if I'm wrong, my understanding is that, as the Honourable Gentleman said, where there are extra checks in specific circumstances on top of the MCA, they are generally specific to those circumstances. So, for example, if you're going to marry, you specifically have to understand what marriage means. But that those have not necessarily been put in law in the Act. They've been added to later, either by specific acts in specific circumstances, which is what we're doing today. So, for example, looking at coercion, which is embedded in the bill, or through the common law in cases where they've said, for example, if you're making a will, you have to understand what a will is. And that this is then laid out in guidance for professionals who are assessing people under those circumstances. Is that a correct interpretation?
I thank the Honourable Member for that intervention. I think he has outlined what I was in slightly more sort of sketchy terms saying, what I was saying around legislation, regulation, training capacity building, delivery, and what he just described is what I was broadly referring to as regulations. But within that, there's a multitude of interventions, which could be code of practice, other forms of legislation, other forms of guidance that the government, common law indeed, jurisprudence, whatever it might be, that a professional body takes as its steer in terms of delivering, and then it's about the judgment, the professional judgment of the professional body.
Rebecca Paul.
I thank the Minister. Shouldn't the government be neutral on what framework this committee might like to apply for capacity?
Minister Kinnock.
The government is neutral on the bill. The government doesn't take a view on the substantial philosophical, ethical, moral, policy considerations, but we do advise the committee, and we are advising the committee on what implications there are for the legislative framework of amendments that have been brought forward. So, in a sense, we're not neutral around whether we think that if an amendment were to pass, it would have very significant operational impacts that could potentially affect the workability of the bill. We're duty-bound to advise the committee of our position on that. So,
Rebecca Paul.
sorry, yeah.
Thank you. I would just say, in terms of you mentioned various moral issues that you're not commenting on, but in reality, the decision on this it increases the number of people that would be considered to have capacity. So I would suggest it is much broader, actually, and so I would suggest it might not actually be a neutral position to be taking. It has a broad
Before
impact.
I come to Minister Kinnock, I am you.
I'm so sorry. I'm so sorry, Chair.
Minister Kinnock.
Well, I'm not sure. Without being able to, without jumping forward into knowing exactly what the implications would be for the number of people which she mentioned, it's difficult to answer that question. But I think fundamentally, the government's position on every aspect of this bill is to be clear that we want the bill committee to make informed decisions, and those informed decisions should be based on whether the government thinks that amendments that are being brought forward would have a positive or negative impact on the workability and the legal framework, and we also have to ensure that it protects the integrity of the statute book.
Naz Shah.
I thank the Minister for giving way. It might not be my last intervention. I think it's an accepted fact. I think everybody would agree that this legislation is new. It's absolutely something that we've not done before. But what I do want to understand, in line of it being new, what assessment, or has the government made any assessment, in particularly with regards to what training would be required and who sets that training for people who would be delivering this?
Minister Kenner.
I thank my honourable friend for that intervention. The bill has a 2-year commencement date, and within that 2-year period, the Secretary of State will be bringing forward regulations to determine precisely the kind of training that is required, the kind of capacity building that's required, and that training will be delivered within that 2-year period. So I think those are the sort of issues that are going to be dealt with if this bill gains royal assent. Turning now to Clause 3, Stand Part. So finally, I will turn to Clause 3 as introduced. Clause 3 sets out that any assessment as to whether a person has capacity to make a decision to end their own life is to be determined in accordance with the Mental Capacity Act 2005. Sections 1 to 3 of the Mental Capacity Act 2005 establish the principles and criteria for assessing a person's capacity to make decisions. Section 2 establishes that a person lacks capacity if they are unable to make the decision in question due to an impairment or disturbance in the functioning of the mind or brain. Section 3 of that Act states that a person is unable to make a decision if they're unable to understand the information relevant to the decision, retain that information, use and weigh that information as part of the decision-making process, or communicate their decision. As the committee will be aware, the Mental Capacity Act has provided a robust framework for important and indeed difficult decisions made for some time and is familiar to clinicians. Chair, I hope my remarks are helpful to the committee in considering the bill and amendments put forward by members. Thank you, Chair.
Kim Ledbetter.
Thank you, Chair, and it's a pleasure to see you this afternoon. I welcome another very good debate on capacity following our previous very thorough deliberations a couple of weeks ago. During that debate, I made my views on the Mental Capacity Act quite clear, and whilst I've listened intently to contributions from colleagues today, my view remains that this well-established piece of legislation is the right vehicle for assessing capacity for the purposes of this bill. Therefore, I beg to move that Clause 3 stand part.
Daniel Francis.
Thank you, Chair. I won't speak for long. I spoke this morning at great depth on my amendment and other amendments. On the stand part of the bill, I think people have heard where I come from on this long and hard over the last few weeks. This is been one of my greatest difficulties, which drove me really to opposing the bill at second reading. I do continue to have those grave concerns around that the Mental Capacity Act 2005 was not written for this scenario. And I draw members' attention to the exchange between myself and my honourable friend from Stroud this morning, where that was accepted, that that decision-making within the Mental Capacity Act, that it has to be presumed that somebody has capacity, and a doctor must assist in those scenarios in that decision-making part of the process. And they have been my great concerns. I'm sure we'll continue this on Clause 4 later, Chair, particularly around the people with learning disabilities. And that is, where I've ended up in this place. What I will say, and I've said this before, and I'm sure I'll say this again during these contributions, people may think that I have a vested interest. Actually, my daughter will never have the capacity to make these kind of decisions. But I do believe I'm here in this committee because there are hundreds of thousands of people in this country involved in family decisions where a child or a loved one does have enough capacity, and the Mental Capacity Act was rightly written, as I've said previously, to allow them to live independently, to buy a coffee, to do their banking. But I don't believe it was written for this scenario, Chair. And I therefore will be supporting the amendments. I presume the amendments may well be rejected, and I look forward in due course to also discussing amendments in the name of my honourable friend from Hackney South and Shoreditch, because I know they bring it into a scenario which does exist existingly within the medical field about discussions with a doctor. But as things stand, I will be supporting the amendments and unfortunately, it is unfortunately, opposing the stand part of the bill simply because I continue to believe, as I did at the second reading, that the Mental Capacity Act 2005 was not written for this scenario.
Amendment 322 proposed to clause 3 as on the amendment paper. The question is that the amendment be made. As many of that opinion say aye. Aye. To the contrary, no. No. Division.
Division in number 10.
Lock the doors.
Cabot.
No.
I didn't hear, sorry.
Sorry, no. It's 322. No.
Lewis Atkinson.
No.
Juliet Campbell.
Aye.
Bambos Charalambos.
No.
Daniel Francis.
Aye.
Tom Gordon.
No.
Sarah Green.
No.
Rachel Hopkins.
No.
Sojourn Joseph.
Aye.
Stephen Kinnock.
No.
Danny Kruger.
Aye.
Kim Leadbeater.
No.
Kit Malthouse.
No.
Sarah Olney.
Aye.
Dr Simon Ofer.
No.
Rebecca Paul.
Aye.
Jake Richards.
No.
Sarah Sackman.
No.
Liz Seville Roberts.
No.
Naz Shah.
Aye.
Dr Neil Shastrihurst.
No.
Dr Mary Tidball.
No.
Sean Woodcock.
Aye.
The ayes were 8, the noes were 15. So the noes have it, the noes have it. Unlock. Does any member of the committee wish to move Amendment 49? No. Amendment 50 to clause 3 in the name of Dr Ben Spencer was debated. The amendment 322 to clause 3. I call Sarah Olney to move the amendment formally.
I beg to move.
Amendment 50 to clause 3 as on the amendment paper. The question is that the amendment be made. As many of that opinion say aye. Aye. On the contrary, no. No. Division. Lock the doors.
Jack Abbott.
Aye.
Lewis Atkinson.
No.
Juliet Campbell.
Aye.
Bambos Charalambos.
No.
Daniel Francis.
Aye.
Tom Gordon.
No.
Sarah Green. Rachel Hopkins.
No.
Sojourn Joseph.
Aye.
Stephen Kinnock.
No.
Danny Kruger.
Aye.
Kim Leadbeater.
No.
Kit Malthouse.
No.
Sarah Olney.
Aye.
Dr Simon Ofer.
No.
Rebecca Paul.
Aye.
Jake Richards. Sarah Sackman.
No.
Liz Seville Roberts.
No.
Naz Shah.
Aye.
Dr Neil Shastrihurst.
No.
Dr Mary Tidball.
No.
Sean Woodcock.
Aye.
The ayes 9, the noes 14.
We're on the
The
way.
noes have it. Amendment 398 to clause 3 was debated with Amendment 322 to clause 3. I call Rebecca Paul to move the amended formally.
I beg to move.
Amendment 398 to clause 3 as on the amendment paper. The question is that the amendment be made. Does many of that opinion say aye? Aye. On the contrary, no. No. Division. Lock the doors.
Jack Abbott.
No.
Lois Atkinson.
No.
Juliet Campbell. Bambos Charalambos.
No.
Daniel Francis. Tom Gordon.
No.
Sarah Green. Rachel Hopkins. Sojourn Joseph. Stephen Kinnock.
No.
Danny Kruger.
Aye.
Kim Leadbeater.
No.
Kit Malthouse.
No.
Sarah Olney.
Aye.
Dr Simon Ofer.
No.
Rebecca Paul.
Aye.
Jake Richards. Sarah Sackman.
No.
Liz Saville-Roberts. Naz Shaw.
Aye.
Dr Neil Shastry-Hurst.
No.
Dr Mary Tidball.
No.
Sean Woodcock.
Aye.
The ayes 8, the noes 15. The noes have it. Unlock. We now come to the question that clause 3 as amended form part of the bill which is debated with amendment 322. The question is the clause 3 as amended form part of the bill. As many of that opinion say aye. Aye. Of the contrary, no. No. Division. Lock the doors.
Jack Abbott.
Aye.
Lois Atkinson.
Aye.
Juliet Campbell. No. Bambos Charalambos.
Aye.
Daniel Francis.
No.
Tom Gordon.
Aye.
Sarah Green. Aye. Rachel Hopkins.
Aye.
Sojourn Joseph.
No.
Stephen Kinnock.
Aye.
Danny Kruger.
No.
Kim Leadbeater.
Aye.
Kit Malthouse.
Aye.
Sarah Olney.
No.
Dr Simon Ofer.
Aye.
Rebecca Paul.
No.
Jake Richards.
Aye.
Sarah Sackman.
Aye.
Liz Saville-Roberts. Naz Shaw.
No.
Dr Neil Shastry-Hurst.
Aye.
Dr Mary Tidball.
Aye.
Sean Woodcock.
No.
The ayes 15, the noes 8. The ayes have it. We now come to Amendment 278 to Clause 4 in the name of Testament, in which it will be convenient to consider Amendments 8, 124, 319, 339, 368, 320, 270, 276 and new Clause 6. Is any member of the committee going to move Amendment 278? We move to the start of this group with Amendment 8. I call the member to move the Amendment 278. Sorry. Okay. Who am I calling? Amendment 8. Okay, I call member
Naz Shaw to move amendment.
Naz Shartman to move the amendment.
Amendment 278, sorry.
Yeah.
I'll be very brief because I think Amendment 278 in the name of my honourable friend, the member for Wells and Mendip Hills, has some merit. It seeks to offer a more formal protection to those who are certain they do not and will not want to avail themselves of the choice to end their life if they're terminally ill at any point in the future. It attempts to do this through an advance decision recorded on their medical records. Being able to record your wishes now, as opposed to at some future crisis point, might allay a number of concerns, particularly for those fearful of coercion. Being able to say, this isn't for me, and knowing that it won't be raised with you, might offer a degree of reassurance for some. So I think this amendment has some merit. It also allows for such an advanced decision to be reversed, so it allows for people to change their mind. What isn't clear to me is how enforceable this provision would be, or what legal status such an advanced decision would have. The aim of the amendment is one I have great sympathy with. I'm therefore keen to hear from the Minister on this point. It may be that an alternative amendment could be proposed on a later clause that achieves a similar aim if this amendment as drafted isn't workable. Thank you, Chair.
Kid Malthouse.
Chair, no.
Amendment 278 to clause 4 as on the amendment paper. The question is that the amendment be made. Kid Malthouse.
I'm grateful, Madam Chair. Thanks very much indeed. I wanted to rise briefly, actually, only to speak to Amendment 368 in the name of my honourable friend and constituency neighbour for East Hampshire. And just to talk a little bit about that issue, I thought it was an interesting amendment to put down, not least because I witnessed the introduction of the Down Syndrome Act back in 2022 by our sadly former colleague, Dr. Liam Fox, a great loss to the Chamber and a casualty of the last general election. His successor should certainly feel guilty of what he achieved, in my view. I'm not sure everybody would share that view, but there we are. Nevertheless, this was an important private member's bill that sought to recognise the status of people with Down syndrome in society, and also to sensitise institutions to their welfare and well-being, and essentially provided for the fact that there should be guidance issued by the government to various institutions across the health service and generally civil society, which would be used to accommodate the needs and, as I say, be sensitive to dealing with people with Down syndrome, particularly as they obviously reach adulthood. However, while I am sympathetic with the aims of the amendment, I do think there are a number of issues with it, and also that its objectives could be addressed and should be addressed, frankly, through other ways. Essentially, that bill, my reading of that bill, Madam Chair, was that it's essentially aimed at institutions. It's aimed at health trusts, local authorities. It's not actually aimed at individual practitioners. Added to that, unfortunately, under that Act which asked the government to issue guidance around Down syndrome, there has been no guidance issued. If you look at we have a rather good legislation website in this House which tells you if a bill has had an impact or had any effect. And if you look at this Act on the website, it will tell you there has been no effect of it yet, and certainly no guidance has been issued. And so I'm concerned about the interplay between the two acts. I do think, though, there are opportunities where we can recognise the particular needs of those with Down syndrome, who very often will be life limited because of their condition, that does need to be taken into account. Obviously, Amendment 394, which talks about advocates, will be important from that point of view. New Clause 8, which I think is coming in, hopefully will be passed, which I certainly will be supporting, has a duty to consult in regulation, and I would invite the Minister perhaps to commit in his winding up speech that groups that represent those with Down syndrome would be part of the consultation package. I'm sure that's perfectly doable. But in particular, Clause 30, which deals with Code of Practice that the government will issue, and in particular Clause 31, which mandates the Chief Medical Officer to produce guidance for medics, and indeed some of the training that will be required should be include modules on dealing with those individuals with Down syndrome. Now, I don't know if anybody's intending to move this amendment. I do think there are problems with it, but my undertaking is to go away and talk to my colleague for Hampshire East and talk to him about what could be done, perhaps at later stages, or indeed whether, yeah.
Thank you, Chair. I will speak to this amendment shortly myself, but would he take the commitment from me that I would happily join him in those conversations, if at all helpful?
Yeah, I'm very grateful to the Honourable Lady. Absolutely, that would be fantastic if she would. However, I do think we could probably deal with the intent of this of this amendment if the Minister were willing to commit, and it's not a big commitment to make, were willing to commit that in the forming of regulations and in the instructions to the CMO to produce guidance, that he would stress the importance of consulting with and dealing with the issues faced by those with Down syndrome, notwithstanding, as I say, the impact of new Clause 8 and Amendment 394, recognising that there is no guidance yet under the Down Syndrome Act, and actually this might be a more kind of belt and braces approach of dealing with what the amendment is trying to achieve than hoping that these two acts will interact in a way that is beneficial to them. Thank you.
Mary Titbull.
I may have risen too soon, Chair. I won't speak to 339, but I would want to hear from my honourable friend who's bringing that amendment first. Sorry.
Danny Kruger.
Okay, all right. I'm very grateful. Thank you. I'm going to speak briefly to new clause 6, in the name of the honourable friend for Solihull, to 368, amendment just mentioned from our friend from East Hampshire, and amendment 270 from my honourable friend, member for South West Wiltshire, and lastly 278 from the member for Wells and the Mendip Hills. But I'll be as quick as I can, just cantering through these. So my concern about new clause 6, which specifies that an advance directive would be inapplicable in the case of assisted dying, is simply to point out, and I think we did discuss this briefly in an earlier session, that the advanced directive is about the refusal of treatment. Currently, that's what they exist to do. Whereas what it states, and it states in the Medical Capacity Act as well, that the effect of an advance decision is that the specified treatment is not to be carried out or continued. But the point about this bill, this proposal under this bill, is that under clause 18, the doctor must be satisfied at the time the lethal substance is provided that the patient has capacity. So I don't think that this clause is necessary. In fact, it's odious or even, I'm afraid, nonsensical, because it's already in the bill. It assumes that the patient has capacity at the very end. The Honourable Lady agrees with that point. So I would invite my Honourable friend to consider whether he wants to push new clause 6 at all. To the amendment related to people with Down syndrome, I hear what my right honourable friend says, and I strongly agree with him. I'll make a couple of points and then respond to his suggestion. I think it is noteworthy, Madam Chair, and I look forward to the honourable lady's points, because I don't mean to make this in a carping spirit, but it is relevant that the National Down Syndrome Policy Group opened their submission with a series of complaints about the process. And I mention it for a reason I'll give, but they state that they feel there's been a rushed consultation process. We haven't had the usual 12 to 16-week public consultation. They talk about limited professional and effective population engagement in the course of the drafting of the bill. They talk about a lack of accessible consultation materials. And I mention that not to revisit the whole debate we had about the process, but because it's a bad start. It's a harbinger in their mind, and I understand why they think this, about how the bill might operate. The fact is, in our society, we have persistent and entrenched discrimination against people with learning disabilities, and particularly, I'm afraid, with people with Down syndrome, a fundamental assumption that is too widely shared, that people with Downs, their lives are worth less than others. And you see this, I'm afraid to say, in the prevalence of prenatal screening and termination of Downs babies. And yet we know from research that the lives people with Downs live are as fulfilling, as joyful, as positive and constructive as everybody else's. We know the most marvellous fact is that 99% of people with Down syndrome say that they're happy with their lives, which is probably, well, I'm sure that's more than this committee. It's probably more than the general population. So you know, we really, I'm afraid to say, as a society, we serially misunderstand and to degrade the value of people with Down syndrome. And they are victims of a system, particularly in healthcare. People with intellectual disabilities died at rates 3 to 4 times higher than the general population during the COVID crisis, often with inappropriately applied do not resuscitate, do not attempt resuscitation orders put on them. And as the evidence we've had from some of the stakeholder groups, and by the way, the representation we've had is signed by 50 organisations, all representing Downs, people with Down syndrome. So this is a pretty widespread representation we've had. And expert advice is that it is very difficult to spot coercion when dealing with people with Down syndrome. It's very difficult to ensure that you are gaining informed consent. And a point that's been made, particularly by the Down Syndrome Research Foundation, is that a discussion with someone with Downs can often feel to them as if it's a suggestion is being made. And it's particularly relevant to this whole question about doctor suggestion, which we're going to come on to. But well, we're on it now. But the question about how a person with Down syndrome receives information, I think needs to be taken into account in the way that we do this work. Very happy to give yeah.
Thank you, Chair. And he's making a really important point. As someone who's got friends with children with Downs, who, as he absolutely says, have very fulfilling lives, I hear every word he's saying. And would he take this commitment from me that he can take back to those organisations? I would commit personally to meeting with them, perhaps alongside the member for East Hampshire and North West Hampshire, at a time convenient to them.
Danny Kruger.
Well, I'm grateful for that, and I'm sure that will be very welcome. It does rather go back to the point they made at the outset, where they wish they'd had more consultation earlier on, but I do understand why that wasn't possible in all cases. Happy to give way.
Just linked into that, point, Chair, I refer back to the evidence given by Fazlet Hadi at during the giving of witness evidence, when she stated, in answer to a direct question from me, that she felt that disabled people had not been listened to properly, and I think it links into that. And would the honourable member comment on that?
Danny Kruger.
I'm grateful to him. I'm afraid that does seem to be a strong impression that many of these groups have had. I just want to quickly quote from a submission that we did receive from someone from it's from the Down Syndrome, National Down Syndrome Policy Group. It's from Fionn Crombie Angus. I'm not sure Fionn has Downs herself or is perhaps a parent, but she makes this, I think, very striking point, which we haven't heard enough. I quote, "I do feel very sorry for the people who are suffering, but I think the people left behind, the relatives, will be scarred for life if they help people die. That's the main reason I do not want the assisted dying bill to become law." And it's not specifically relevant to this question, because we're not discussing whether the whole thing should happen or not. But it struck me that there, from a member of the Downs community, you have a point that I think goes to the heart of the discussion we're having in this bill, which is that it's not all about the individual who's seeking an assisted death as well. There are more people involved in that decision. And the point I made in an earlier debate about relational autonomy, I think is very, very significant. And that particularly applies to this group of people who will be making decisions in the context of their family, in the context of the people around them, and including in the context of the doctor who's talking to them. So that's why it's particularly important that we have a wider set of expertise and advice around people with Downs. So my concern is that the bill will currently, and thanks to the inclusion of Clause 3 of the Mental Capacity Act, it will actively support, it will assume consent for people with Downs to receive this intervention. It would have been best, in my view, if we had accepted the amendments tabled by honourable members for Reigate and Bexley Heath to reverse the burden of proof. But failing that, I think what we need to do is ensure that the job is done properly. And the amendment from my right honourable friend from East Hampshire addresses that point. And given the real concern that we have all discussed around the application of the Mental Capacity Act, I think it is important that real expertise, time and attention is given on behalf of Downs people. So the role of an independent advocate, particularly someone who has themselves expertise in end-of-life decisions for people with Down syndrome, which is going to be a small group of experts, but we might end up having to widen that, I'm sorry to say. But we do need people with proper expertise. To my right honourable friend's suggestion, I think maybe he's absolutely right. So I'm prepared if his point about the interaction with the Down Syndrome Act from a couple of years ago with this Act. My understanding is, yes, he's right that it does apply to authorities, but it strikes me that the purpose of this amendment would be to insist that the provisions of that Act apply in the case of individuals as well. But he might be right that there are complications there. So it would be good to hear from the Minister whether he agrees with my right honourable friend that we should take this topic away with the Honourable Lady and see whether the provisions that are in the amendment can be introduced either in later stages or in statutory guidance. But I would want to hear that quite explicitly from the Minister, that he is confident that what the Right Honourable Member who's tabled this amendment is trying to do will be reflected properly in later stages of the bill. And on that basis, I'd be happy to not push the amendment unless others feel strongly that we should proceed. Just to the Amendment 270 in the name of my Right Honourable friend and my neighbour from southwest Hampshire, southwest Wiltshire, that's where I am. There's been a lot of Hampshire. He's my neighbour too, on the other side. This is about the importance of ensuring that any remediation of suicidal thoughts has been properly provided. So NICE guidance says that if someone is at risk of self-harm or suicide, a clinician must ensure a psychosocial assessment has been carried out, either by a mental health specialist or by a trained person in primary care. That should cover the person's living arrangements, relationships, social support network, mental health disorders, risk factors, safeguarding concerns, and so on. And Professor House told the committee that this should be part of the assessment for assisted dying, saying his point is the current assessment only answers the question, is this person able to make decisions? So it goes back to our ongoing conversation about capacity. The current requirement does not cover psychological and social assessment. Now, depression is a very common issue with terminal illness. And depression is strongly linked to a wish to hasten death. And I apologise, I know members don't like it, but I've got to refer back to the fact that we are talking about suicide here. There is a reason why people commit suicide or think about committing suicide after they've had a bad diagnosis. I know that part of the purpose of this bill is to relieve those people of the agonising obligation that they feel to take their own life in brutal and traumatic ways. The fact is, we also know that suicide is most common soon after diagnosis, not shortly before death. It's more common immediately after diagnosis than later on. And people frequently come to terms with their diagnosis, receive treatment, and recognise that actually the best thing for them and their family is for them to go on living, longer. Happy to give way.
Dr. Simon Orfer.
Surely you're describing exactly why we need this bill, because if they're given a diagnosis, at that point they can apply for assisted death. We know that there are statutory time limits built into that, so which will take us, I believe, to 21 days at least from the diagnosis. The danger, and what we're trying to do here, is to avoid suicide in patients. Approximately 600 in this country patients with terminal illness commit suicide. So this bill will prevent that by allowing them to apply for assisted death.
Danny Kruger.
Well, I hope the Honourable Member isn't suggesting that all 600 would be averted by this bill, but he might be right that some would be, and I recognise that. However, the purpose of the amendment is to ensure that people who might be suicidal, and whether they're inclined to apply for assisted death if it's legal or to take their own life in an unassisted way, nevertheless, if they expressed a wish under the clauses of the bill to have an assisted death, they would have proper psychosocial assessment and proper steps to be taken to ensure that, is this in fact, if we're prepared to make this distinction, or is it just that they are suicidal, not wanting an assisted death? I find the distinction difficult to logically pass, but if that is the distinction that we are making, let's put it into the bill and ensure that people are properly cared for in that very dangerous time after they get a terrible diagnosis. So, just to quote from written evidence we received from a member of the Pathfinders Neuromuscular Alliance, which is a user-led charity for those with muscle weakening conditions like muscular dystrophy. This person said, I quote, "I've been there, I wanted to die, and I've been in the position where I would take that option if it was given to me. Not if it wasn't. I'd take that option if it was given to him, interestingly. Rather than suggesting he was going to take his own life anyway. But looking back," continuing the quote, "looking back, I can see I was depressed, and now I'm so glad I didn't take that option." So at the moment, the bill does not require anyone to explore these psychosocial factors. And although the person can be referred to a psychiatrist, and they must be, if we accept the amendment, if the doctor concludes that there is doubt, I want to quickly refer to that point, because the assumption of this new amendment, they will refer the person to a psychiatrist, it's only if they've done their own assessment well. So we are assuming they will do the assessment well. We've heard repeatedly that these assessments are often not done well. But I welcome the amendment that's coming, that if they do conclude that there is doubt about capacity, they must refer. That is a step forward, but it's not sufficient. There's still only, even the psychiatrist will only answer the question, is this person able to make a decision? It doesn't address any of these other factors. Now, in Oregon, and we refer often to Oregon, and this bill is supposed to be the safest in the world, it's not as safe as Oregon in this respect. The doctors may refer the patient for counselling if the patient may be suffering from a psychiatric or psychological disorder or depression causing impaired judgment. So, just to conclude on this, psychosocial care is fundamental to good end-of-life care. Members of the committee have said that palliative care and assisted dying can complement each other. This assessment should be part of that picture. And this needs to come before the first declaration, because once somebody has signed that declaration, they're already on the pathway. And then there's not going to be an obligation on them to receive palliative care advice either, because we rejected that amendment. This amendment provides an opportunity for people's needs to be met at the first opportunity. Lastly, Madam Chair, I'll wind up shortly. On the question of doctor-initiated conversations, I want to quickly point out that how important it is to recognise the difference. Let me just it's easy just to quote Professor Brassington, who submitted evidence to us. In normal medical practice, the patient approaches the medic with a problem, and the medic suggests possible courses of action, not all of which will have been considered by the patient. The patient permits further action, but it is implicit that the practitioner who makes the suggestions thinks they are good, thinks these suggestions are good, and the patient is entitled to think that the practitioner endorses them all. So in a normal scenario, the doctor would think about what is good for the patient. To raise an option is to endorse the option, to encourage it, perhaps as one among a number of other options. Well, it is to suggest that this is a good option. It might not be the one the doctor thinks is the best, but it is a good option for the patient. Otherwise, they would not be...
Would you give way on that point?
Otherwise, they would not be making... They can only make a recommendation for options that they themselves consider would be appropriate to the situation.
Kim Ledbetter.
Thank you, Chair. I think on that point I would fundamentally disagree, but I will stand to be corrected by medical colleagues. I don't think the doctor in this instance is making any suggestion. What they have a responsibility to do is lay out the options, but it is up to the patient to choose. And I would imagine, again, stand to be corrected by medical colleagues, that that is standard practice.
Well, I think this is a very important debate to have, because the clear implication of a doctor making a recommendation is that this option would be good for the patient. It's one of many. Well, no, indeed, it's not a recommendation. In laying out this option for the patient, the doctor is clearly communicating that this might be the right thing for the patient to do. This might address their needs. Yes, that is, and if the suggestion is that they're making a suggestion which might not be good for the patient, then that is of serious concern to us, is it not? So the clear implication of current law, and indeed it refers specifically to Montgomery, which determines that we have patient-led medicine in this country now. A doctor is obliged to set out all of the appropriate options which he or she thinks might be appropriate to the case. And it does go back to this question about whether we regard assisted dying as a healthcare intervention or not. But if we are regarding it as a healthcare intervention, then if it is suggested, it's because it might be the right thing for the patient to do. So implicitly, there is a suggestion that this could be the right option for the patient. And it's interesting that Clause 4, subsection 1, disapplies Montgomery. So it says that, in fact, a doctor is not obliged to make this suggestion, which raises the question about, asks the question, is it therefore a treatment at all? Yeah.
I'm not sure he's entirely right. My understanding is that under law and medical ethics, doctors have to recommend or have to discuss all course of actions to you, even if they believe that a course of treatment might have adverse consequences. It's not that they can restrict themselves, they have to give you the full, and that sits behind informed consent, surely.
Well, certainly there are adverse consequences for all sorts of treatments, but putting it on the table, making it clear that this is an option for the patient, can only be done morally and legally if the doctor thinks that it may be an appropriate treatment, intervention, for the patient. So there is otherwise, if we're suggesting that the doctor might not think that this is a good thing for the patient to be doing, it's a serious breach of medical ethics for them to be suggesting it. So it's one or the other. Either this is a good thing for a doctor to be suggesting or it's not. Have to give way.
Thank you for giving way.
Judy's Counselor.
Thank you for giving way. Very quick question. Would my honourable member agree that the weight of a doctor's words weighs heavily on patients?
Danny Kruger.
Well, I'm absolutely sure that that is right, and I'm grateful to her for making this very important point. For anybody, but particularly for the vulnerable, particularly for those in distress, as people are towards the end of their life, particularly for those who've had a terrible diagnosis, but also for those people who feel a burden, and recognise that the coming months might not be good for them or their family. Of course, this statement of this option, even if it's presented as neutrally as possible, has an implication. It might well be received as a communication that the doctor is actually trying to say you are going to have a terrible death, and not wanting to say it out loud. So it can be taken in all sorts of ways by patients. I'll give way to the honourable gentleman.
Dr. Simon Orr.
I think actually this is not right. What happens in a medical consultation is you give a number of different options. For example, just a small example, I might suggest to someone that there is an option of taking an antidepressant. Now, it's the patient's choice whether they do that. My role is to give every option that is available and encourage and help the patient make their own personal choice. And that's a very basic tenet of clinical care. Thank you.
I recognise that, but I repeat, by offering antidepressants, he is suggesting to his patients that it may well be the right thing for them to do. This is you put in front of your patients a menu of options with more or less advice according to your expertise. But if on the menu is assisted dying, that's because assisted dying is regarded as something, as it were, healthy to eat. You wouldn't be putting something on the menu you didn't think they should take. So everything on the menu is edible.
And maybe we have a different interpretation of the Montgomery case about it, but my interpretation of that case was that it shifted from what a reasonable doctor should disclose to what a reasonable patient would want to know in terms of the duty of doctors. And in these circumstances where I'm facing I've got a terminal diagnosis with only a few months to go, I guess what we're saying in this bill is that a reasonable patient would want to know about this option.
Danny Kruger.
I think he's suggesting that in every case a doctor should suggest assisted dying as an option. Because if he's suggesting that a reasonable patient would want to know this towards the end of their life, he's saying that every dying patient should be told, what about assisted dying? I think that's a very, very concerning suggestion that we've just heard. So the question is, how would a doctor decide when or when not to make this suggestion? And I want to go back to Montgomery, and I want to make this point clearly as I can. The bill accepts that assisted dying is not an ordinary medical treatment. That's why I was pressing the Minister on this question. Because Clause 4.1 disapplies the Montgomery case law, which requires, as part of informed consent, that the patient be informed of all appropriate options. Having conceded that assisted dying is not an ordinary medical treatment, the objection to a prohibition on doctors raising these makes little sense. Having such a prohibition would be unlike any other medical treatment. Yes, it would. But the bill already has crossed the Rubicon of saying assisted dying is different from all other medical treatments because in Clause 4.1 it says that doctors are not obliged to offer it. So it's either you must offer it or you mustn't. There's no grey area. If you don't have to suggest it in any case, this implies that assisted dying is actually unnecessary in all cases. If you don't have to suggest it in any case, you're implying that it's not necessary in all cases. And there are no cases, indeed, when it should be used. And I'd like to hear from any member who has got an answer to this. In what circumstances might it be appropriate for a doctor to suggest assisted dying? Happy to.
Mary Titbull.
Does he therefore disagree with the BMA, whose own evidence to us as a committee said specifically, and I quote, "We support the bill's balanced position such that there is no prohibition on raising assisted dying with eligible patients where, in their professional judgment, the doctor considers this to be appropriate, but there is also no duty to raise it." The implication being that the bill gets that balance correct.
Danny Kruger.
Yes, I'm grateful to her for highlighting that. I do disagree with the BMA. I think their idea of a balance is actually an incoherence in the bill. And I know that the BMA elsewhere have suggested that assisted dying should not be regarded as a normal healthcare option, as a healthcare treatment. I think they are themselves victims of the confusion that is reflected in this bill about whether this is healthcare or not. And as I've said, the disapplication of Montgomery in 4.1 suggests that it is not actually a healthcare treatment and should not be managed in the same way as everybody else. Happy to give way.
Jake Richards.
I'm very grateful and I've been listening to the argument in some detail. Is there not a danger here of trying to translate the dry words of a clause in Clause 4 to the conversations that naturally happen between clinicians and patients, Chair? And subsection 3 attempts to give some discretion as to when, how and if to raise this prospect, which is, instead of making it mandatory on any prognosis of terminality.
Danny Kruger.
Well, yes, I recognise it's an attempt to give maximum leeway to doctors, and I think that is dangerous, and it puts doctors in a very difficult position. So to the point of the BMA, who have said that they think that it's appropriate to enable doctors to raise this option as if it were just another treatment, even though they've also said it's not just another treatment. I'll give way in one moment. Let me just challenge the BMA with the Medical Defence Union, which is the union that supports doctors in litigation. They point out, I think more correctly, that this is the worst of all worlds for doctors, because they would be liable to complaints in either situation. You know, if they do not raise it, a complaint can be made against them for not having done so, and if they do raise it, a complaint can be made against them on those grounds. So we're being extremely unclear, I think, by leaving it entirely up to doctors. And as I've said, it is not clear to me what are the circumstances in which it would be appropriate for a doctor to suggest an assisted death to somebody who has not raised it themselves. I'd very much like to hear somebody tell me what those circumstances might be, to paint a scenario for us in which it's appropriate. Let me give way to my honourable lady.
Thank the honourable member for giving way. Surely all medical codes of practice explicitly or implicitly bar doctors from raising courses of action that they believe could unquestionably harm a patient. Does it therefore not follow that doctors only raise courses of action for patients that they believe will not unquestionably harm them, even if they believe some courses of action are more likely to be in the patient's best interests than others? Might catch a comment.
Danny Kruger.
Thank you. Thank you, Joe. That's absolutely right. Yes, indeed. It's, I mean, as I say, either this is a medical treatment in which it should be obligatory for a doctor presented with a patient who qualifies for the bill, who has the symptoms that we're talking about. It should be obligatory on them to say, by the way, there's also this option, which I think is what the right honourable gentleman was suggesting. Or it's not a healthcare treatment at all, and as is implied by 4.1 here, it says they don't have to raise it, in which case they should not raise it. Because to raise it is to put it on a par with other healthcare options, and very implicitly, or indeed pretty explicitly, to say this is an option which might be good for you, which is an enormous communication to make. And to go back once again to the question of the difference between this and withdrawing treatment. I've said it so many times because it's so important. This is not equivalent to withdrawing treatment because this is not specific to the illness that is being treated. You can have a treatment or not, and that will address the condition that you are suffering from. The termination of your life does not address your symptoms, your treatment, your condition, your illness. It kills you. It's a different order of intervention. I don't think it's a healthcare treatment at all. And it should not be treated as such. Happy to give way. Moment's passed. Sorry, I think I was ready to give that. Oh, maybe it was an honourable lady. Sorry.
Kim Ledbetter.
Thank you, Chair. I think he makes a really valid point in terms of what circumstances would this be considered a valid choice for a patient. And I think it brings us back to the question of, this is someone who is going to die. And the question is how they are going to die. It's not someone who's going to get better. They're not going to wake up and everything's going to be fine. So it's what that death looks like. And if we think of the example of one of the witnesses who gave evidence, I think it was Pat Malone, who had a brother who had seen his father die under very horrible circumstances, and so much so that he had begged his children to help him die. And then he got the same condition. So for him, he can see what his death could look like. Does he not value the choice that assisted dying would give that patient to take back control of what their death could look like with their loved ones around them? This is a very real situation for some people, for sadly lots of people, and that could be where this choice could be valid. Danny Kruger.
Thank you, Chair. I wasn't asking for cases in which it might be the right choice for somebody. I recognise the argument made there. I'm asking when it might be appropriate for a doctor to suggest it. In the case of the Malone family, if this law had been in force, they would have requested it themselves. So again, I want to know under what circumstances it would be best for them, it would be in the patient's interests, for an assisted death to be suggested to them, to be raised by the doctor when they hadn't raised it themselves. Under what circumstances might that happen?
If you may allow.
Kim Ledbetter.
Thank you, Chair. I think the concept of a suggestion is also not particularly accurate. It is a choice, in the same way that the other options are a choice. And you know, families could only ask for this conversation if they knew about it. And whilst we are all living and breathing this bill at the moment, even if it does come to fruition and the law is changed, there will be people who don't know about this option. And surely it would not be informed consent for a person to suffer a horrible death if they were not told about this option.
Danny Kruger.
I mean, I think we are talking, the suggestion that people won't know that this option is on the table. Who are we talking about in those circumstances? I suggest we'd be talking about people extremely marginalised. And I'd be very concerned about a doctor suggesting an option to them. So no, I mean, and if there is a tiny number of people who wouldn't know that this option is legal, I'm afraid it will be very widely known the minute it is law. I will certainly give way in a moment. There is an enormous number of people who will be dragged into the scope of this bill by suggestions being made to them, the vulnerable people that we are concerned about. And I really do invite her to answer as honestly as she can. Does she not accept that being given this option by a doctor, in the power position a doctor has, in the vulnerable position that the patient has, could well be interpreted as a suggestion that this might be a good thing for them to do? Does she not recognise that? I'm sorry, I'm not...
But we shouldn't be addressing...
She's absolutely right. I'm inviting her to intervene if she wishes to, but I recognise she doesn't have to do that at all.
She's not an acceptable term in this room.
The Honourable Lady, is she not an acceptable term?
But no. You shouldn't be addressing the lady. You should be
addressing
the chair.
Okay,
Thank
I recognise that. I should certainly address you. Happy to give way.
Dr. Simon Orber.
Yeah. Because I'd like to sort of make a speech which answers some of these, but I will intervene if that's more appropriate. What would you prefer?
I don't think that's the microphone. Thank you.
Sorry, Chair. I should address that.
That's not a decision for Mr. Kruger. If you wish to make a speech, if you indicate to me as the chair, I will call you at an appropriate time. If you wish to make interventions, please do so, but can you keep them short? Have you decided which option you prefer?
I think I'll decline his intervention. How about that? I'll make his decision for him. Would that be acceptable? I look forward to his speech. Let me wind up to the general satisfaction of the committee with a couple of points about some other amendments. So, the one moved by the Honourable Lady, tabled by Member for Wells and Mendip Hills. This is a very south and southwest debate we're having. Now, the suggestion here is that if somebody has indicated in advance that they do not wish to have a conversation about assisted dying, the doctor will not raise it. Well, that sounds welcome, but I'm afraid in practice I think that this is quite simply an invitation to raise the idea if the declaration has not been made. The absence of the declaration could well be interpreted as a willingness to have that conversation. I mean, and practically how would it work? Would patients be informed of the need to make a declaration in advance of a doctor's appointment, would we all have to think, goodness, if I don't make this declaration, the doctor might be suggesting assisted death to me. So we all do that. Suddenly we're having discussions about assisted death even before we see a doctor. All over the Mendip Hills, they'll be worrying before they see a doctor that they better sign a declaration. And it just does actually, quickly, to make a serious point, I think it refers to the fact that while this bill is frequently framed as a choice only for the people who might take it, and with no impact on the rest of society, my great concern is that actually what this bill will do is impose an obligation on every family with a frail or elderly person in it. It will impose an obligation on all of us as we approach our end to consider whether we should take this option or not. It is not, not neutral in its effect on everybody. And my concern is that the amendment suggested by the Honourable Lady will bring this home and make it even more explicitly required that we all consider whether we want to have an assisted death well before the time comes. So just to finish, happy to give way.
Tom Gordon.
I thank the Honourable Member for giving way. I think there is already a broad consensus in this country that assisted dying is something that people would like an option. We know that from polling that shows overwhelmingly support for that option. What that option looks like, I accept there are disagreements within that, but this isn't something that would now suddenly just pop into people's minds that they've never thought about before. I think, as we've seen, over decades and decades, this is something that people have already been talking about. So what would you say to that?
Danny Kruger.
I'm grateful. He's right. It's something that people are well aware of as a topic, in fact, and they'd be very quickly aware of it as an option if it became law. Without getting into the question of the bogus polling that claims to demonstrate public support for this, I would simply observe that, what it does, it demonstrates support for something called assisted dying. If you drill into the data and ask people explicitly what they mean, often they mean palliative care. The understanding of what is actually proposed in a bill like this, the more people understand it, the less they like it. And actually there's a majority against the provisions of this bill in other polling. But let's not banter polling around here. We make the law and we're not responsive to polls, are we, Madam Chair? So, just to conclude, with the points about, and I just do apologise. I wanted to. I've completely lost my way. Oh yes, the point. I do think there is a challenge around making these advance notices, and my strong suggestion would be we don't proceed to support 278. And I think I'll better leave it there, Madam Chair. I think we've all had enough of me.
Julian Campbell.
Me included.
I will be speaking to Amendment 124. And the amendment prevents a registered medical practitioner from discussing the provision of assistance under the Act unless it's first raised by the person themselves. It's very similar to discussion that we're going to have here. And the reason for my amendment is that the doctor would be suggesting, offering or endorsing assisted dying as a treatment pathway, and that would be me. And the patient may take it as a recommendation or an endorsement. And this can actually impede on the freedom of the individual to autonomously choose assisted death. There's another reason why I put this amendment in. It's because it risks exacerbating our already existing pervasive health inequalities. I'm very concerned that biases, both conscious and unconscious, have the potential to significantly impact upon the treatment pathways offered to people, particularly those that fall under the 9 protected characteristics of the Equality Act 2010. Medical practitioners have the potential to influence treatment pathways offered to people from particularly those backgrounds. And I therefore see no reason why assisted dying or an assisted death would be offered as a treatment pathway. An example I was thinking of with this is that maternity services, under maternity services, we also have abortion services. But if a person presented themselves to a doctor and said that they are early stage of pregnancy, one of the options offered to them would not be abortion. It would be, do you want to have your baby at home or do you want to have it at the hospital? Would you like shared care between your GP and the hospital? They wouldn't say, or would you like an abortion? because that's not part of the pathway. The person would come to the doctor and say, I am pregnant and I would not like to have this baby. So therefore, it is important that the individual first approaches the doctor, the clinician, and says, I am interested in, or I would like an assisted death. So it shouldn't be a treatment option, even if it is part of end-of-life care. The doctor's position is one of knowledge and expertise that far exceeds that of their patient. And this places a doctor in a position of power and influence over a patient. So where there is a power imbalance, a suggestion of the doctor seems like a recommendation. If an individual chooses assisted death because to them it feels like a recommendation, that decision is no longer autonomous. Now, I'm going to quote from a GP, Dr. Hannah Denno, who put in some written evidence. And she cited her role as a GP as one that leads her patients to take her words as guidance or even advocacy for certain treatment. She goes on to say, I believe that in my role as a GP, to make a suggestion, such as choosing assisted death, would put pressure on some patients to accept it at a time of vulnerability where many patients are very sensitive to any suggestions made by healthcare professionals. And this is actually corroborated. I'm going to give another quote. It's from a senior lecturer from the University of Manchester, who says that the freedom of a registered medical practitioner to discuss the option of seeking help to die is ethically problematic. The usual therapeutic interaction between patients and I'm going to say RMP, involves a patient seeking advice about their condition and the RMP offering their expert opinion, advice and information about possible treatments. Any treatment suggested should be in the best interest of the patient and deemed reasonable and responsible according to clinical, legal and ethical standards of care. Professional advice regarding treatment will be received by the patient as a recommendation or at least an option that the RMP deems appropriate. So there are many, many examples of where we recognise that the weight of a doctor's words carry a lot for a patient. So if a doctor is offering a course of action, there's an expectation, rightly or wrongly, that it might be in your best interest to pursue that course of action. And if that option is of assisted dying, it is a suggestion to the individual. And therefore it's a strong feeling amongst many medical professionals that a suggestion is also a recommendation. Accordingly to this, the understanding of a doctor-patient relationship is always about the well-being of the patient. And to present assisted dying alongside to present assisted dying alongside other treatment options is problematic. Skip that a little bit. We can assume that people who know, so we can assume that people will know about assisted dying and it's an option open to them. One of the healthcare professionals from California who gave oral evidence said that in California only a quarter of the population were aware that assisted dying was a legal option. And it was a concern to that practitioner that they were unable to first raise assisted dying. However, it seems incredibly unlikely that this will be the case in England and Wales, given the high-profile nature of the current proceedings and the significant change it will mark for healthcare services. It will be all over the news. Everybody will know that there would have been a change in the law. So unlike America, where the laws vary from state to state, the law would apply nationwide across England and Wales. And it seems likely that citizens in England and Wales will be aware that some form of assisted dying is permitted, even if they are vague about the details. And I'd anticipate that the long-term public awareness will be much like abortion, i.e. the public know that it's lawful and they have an understanding that a person can get an abortion, but they don't actually know what exactly it all means. They don't know what the law, the Abortion Act of 1967 means. So the fact that people will have knowledge that assisted dying, legal assisted dying, is available in this country is enough for people to be able to first go to the practitioner and make that request. My second concern is regards to healthcare professionals first raising assisted dying as a care pathway is the potential impact on our already known health inequalities. Across our healthcare systems, poor health outcomes for marginal groups are a pattern we've understood for decades. In a report of the, on black maternal health care, it says there is glaring persistent disparities for outcomes for women depending on their ethnicity. Maternal mortality for black women is currently almost 4 times higher than for their white counterparts. Significant disparities also exist for Asian women and women from mixed ethnicities. These two disparities have existed and been documented for decades, but have only recently received mainstream attention since around 2018. That means if there are disparities in the way that assisted dying is offered if a patient cannot go to the doctor first, we will only know about them many, many years later. So a safeguard is that the doctor does not approach the patient first. We've heard in this committee many times that during the pandemic, disabled people were subject to DNR orders. The Disability Rights UK says it is unclear how many of those deaths could have been avoided with greater access to treatment and resuscitation. A public health report on the early pandemic showed that adults with learning disabilities were overrepresented by over 3 times among those who died during the pandemic. There are other people who have said many things around deaf and disabled people's impact and the way that they are treated. But the Deaf and Disabled People's Organisation said, at present, it presents this bill, or if a doctor could first approach a patient, it says, at present, there is a serious risk for medical coercion. Negative judgments made by medical professions about the quality of deaf and disabled people's lives too frequently result in deaths by neglect and denial of life-saving treatment and was starkly highlighted during the pandemic. If we're to acknowledge the trend of health inequalities that it presents us with an unquestionable quandary when we are regulating assisted dying. People that fall under the protected characteristics and those from less privileged backgrounds may be more likely to be offered assisted death instead of more involved palliative care, whether that is due to unconscious bias, stereotyping or discrimination. By removing the option of a healthcare professional first raising assisted dying with the patient, we seek to alleviate the risk that already marginalised groups are put in with regards to assisted dying if a healthcare professional would suggest it to them first.
Neil Shastri Hurst.
Thank you very much, Chair. It's a pleasure to serve under your chairmanship. I wish to concentrate my remarks on New Clause 6, which was tabled under my own name, but also Amendments 8 and 124. And I'll be clear from the very beginning on New Clause 6. This is a probing amendment, ready to air the debate in order that it's on the record. And the reason I tabled this amendment was the interplay between the bill as currently drafted and with Section 26(1) of the Mental Capacity Act. And of course, Section 26(1) sets out that a decision has effect as if it had been made, as if it had been made, and the individual who had made it had capacity at the time, for when that, at the time that the question arises whether that treatment should be carried out or continued. Of course, an advance directive relates to those decisions around the removal of treatment. The mischief that I was seeking to address with this, of course, there are those patients who, were this law to be enacted, would continue with their palliative care treatment right to the very end before they choose to have an assisted death. And so technically there could be a scenario where that person loses capacity from the point at which they have gone through the 2-stage assessment by a doctor. It's been approved by the panel if that is approved in subsequent amendments. They lose capacity, they've set out a desire to end their life through an assisted death. But there would be the removal of the palliative treatment options at that point. And so it's that conflict
between something that would be contained within an an advance directive that would enable the assisted death to take place, which would involve the removal of care. I will give way to my honourable friend.
I'm grateful to him for setting it out so clearly. I'd like a little more clarity. I don't fully understand, because my understanding from the bill is that at the moment of the administration of the fatal drugs, the final act, as it's called, the administering doctor has to be confident of capacity at that point. So if they were no longer, conscious, they would not be able to proceed.
Neil Shastri.
And that is the purpose of this new clause, to get clarity on that issue. Because, as I say, the interplay with subsection 26 of the Mental Capacity Act, which states that if a patient has made an advanced decision which is valid and applicable to treatment, the decision has effect as if he had made it and had capacity to make it at the time when the question arises whether the treatment should be carried out or continued. So I'm not suggesting for a moment, and I will take an intervention in a moment, for a moment that seeking an assisted death is conventional treatment in the normal sense of the word. But there will be those patients who seek an assisted death, but also have palliative care treatment along the way. And therefore, there could be a scenario, right? It's a technical scenario, whereby there's the withdrawal of the palliative care treatment in order for the assisted death to take place. So, as I say, there is an element of mischief within this probing amendment, but it's to air the debate, because in truth, I think the reality is, with any withdrawal of treatment, with any intervention of treatment, there's a variety of options that take place. But I wanted to put it on record. I have had some assurances from the bill proposer, Chair, in advance of today, that, in fact, that is clearly not the intention of the bill. And in many ways, arguing against my own amendment. Of course, this is a distinct scenario from an advanced statement. An advanced statement which is a much more proactive step of these are the treatment or options that I would like if I lose capacity at a future date, has no legal footing compared to an advanced directive which is very much concentrated on the withdrawal of care. So I'm not proposing to put this forward to a division. I merely wish to put it on the record in order that it had been discussed. If I could perhaps concentrate more substantively on Amendments 8 and 124. And there has been a lot of discussion and worthy debate on the position of Montgomery in relation to this amendment. And it takes me back to my days as a pupil barrister, grappling with the issues of consent. But actually, I fear we may be going down a rabbit hole when we're discussing Montgomery in this context. Because I agree with my honourable friend from East Wiltshire that an assisted death is not typical medical treatment in the normal sense of the word. It is a wider holistic medical intervention, but it is not typical medical treatment. And therefore, under my understanding of Montgomery, that would not apply in those circumstances. But I think that some of the principles around Montgomery may well have justification. My concern about Amendments 8 and 23 are that whilst it is quite right that there should be no requirement to instigate those discussions, it would be equally wrong not to have the flexibility to have that conversation in the appropriate circumstances. And the reality of clinical practice is that there are consultations within consultations. A patient comes to a surgery, they come to see their doctor, and they may not feel able to articulate what they are truly feeling. There may be some subtle hints, and these are hints that doctors pick up on during the course of a long career, of reading in between the lines, to put it in perhaps lay terms. And where I think there is an interplay with the principles of Montgomery which were very clear that a doctor should discuss issues where a reasonable person in the patient's position would attach significance to them, or the doctor is or should reasonably be aware that that particular patient would attach significance to them. Are those scenarios, and my honourable friend asked for examples of these, where there have been some subtle hints from the patient that they've been given a terminal diagnosis, they've been told that they ask, what's the implication of this terminal diagnosis? How am I going to die, doctor? And you say, well, you know, there are a variety of ways in which this may manifest itself, and you go through those, some of which may be more tolerable to the patient than others. But take the example of bowel cancer, for example. It would be inaccurate not to include in that discussion, if a patient is directly asked how they are going to die, that there is a possibility that your bowel will obstruct. And depending on where your bowel obstructs, you may suffer from significant bloating, pain, discomfort, but you also may have fecal and vomiting. You may be vomiting for hours. You may be even vomiting for longer than that. And they may say, well, doctor, I hadn't even thought it was going to be like that. I thought I would slip into a coma. I would gently pass away with my family around me. I hadn't even crossed my mind that it may be a more uncomfortable or painful or unpleasant death. I don't want that. I don't want that. What can I do? Well, under the amendments that's been proposed, the doctor would not be able to raise assisted death at that point, which is, if this law passes, an option that's available to them. It may not be an option that is palatable to some people, even after the debate. People may have for very valid reasons, a moral objection or a principled objection to anybody undergoing an assisted death. But once it's on the statute book, it is an option to individuals. And the danger is that we place our clinicians in an unenviable position. We cannot force them to have that conversation. But if the patient clearly indicates that they want it, that they've made that indication, that they want to know what options are available to them, where does that leave the clinician? I will give way.
Danny Kruger.
I'm very grateful to him for setting out so clearly the scenario that he describes. So just to summarise it, he is suggesting that if a patient with bowel cancer says to their doctor, how am I going to die? The doctor would say, well, one possibility is that you'll die very badly with vomiting feces. To which the patient says, my goodness, I'd never thought of that. What can we do about it? To which the doctor should say, well, there's always assisted dying. I mean, I summarise and I condense the conversation. But that is the conversation that he's envisaging, is it not?
Neil Shastri-Hurst.
I'm grateful to my honourable friend for that intervention. He summarises a conversation, a much more complicated conversation. I think he distills it, my honourable friend distills it down to an oversimplistic representation of how that conversation would go. A patient, so I hadn't envisaged that I may die whilst vomiting up faeces. What would we do? And you would go through a variety of options that would be available in that scenario. But that would include, potentially, having a discussion about assisted death. That would include that discussion about, that would be one way of avoiding that situation coming across the hills. The issue that I have particular concern with is, take the scenario where that conversation arises. And a patient has very clearly indicated that they want to know all the options that are available about how they would manage their death. The doctor feels that that is a cue, quite understandably, and in my view rightly so, to have a conversation, a wider conversation that involves assisted death along with other options. Because he or she believes that the patient has indicated that that is what they wish. You then open up the clinician. If you say that a doctor cannot have that conversation in any circumstances, you open up the clinician to the accusation by perhaps a relative who says, well, hang on a minute, doctor. My relative didn't raise that with you. You raised it with them. These are very subtle and carefully balanced conversations. I understand where this comes from, but without giving and entrusting in the judgment of clinicians who know their patients well, we are setting them up to fail. We are setting the system up to be more clandestine. We are going to prevent what are very genuine and important conversations taking place because people are too scared because of the operational framework that would be imposed upon them. And in those circumstances, we would only be serving of putting forward a bill that is not functional for the intent that it is due to have. And for those reasons, I will not be supporting Amendments 8 and 124.
Daniel Francis.
Thank you, Chair, and it's a pleasure to serve under your chairship. I'll start by moving the 3 amendments that stand in my name. So, firstly, in Amendments 319 and 320, which stand in my name, Clause 1 of the bill outlines that this legislation relates to a terminally ill person who is aged 18 or over at the time the person makes the first declaration. It does not, however, refer to the age that an individual needs to be at the time of an initial discussion in line with Clause 4 of the bill. The definitions within the Men's Capacity Act, which has now been agreed as part of the bill, relate to those aged 16 and over. And given we've now accepted that, I presume that those discussions in Clause 4 could certainly be held with 16 and 17-year-olds. I appreciate there'll be different views on this matter in relation to autonomy, but I do think some of the strongest supporters of the bill will be uncomfortable with those conversations being undertaken with someone as soon as they turn 16. My amendments seek to ensure the bill includes the strongest possible safeguards, ensuring that these aspects of the bill relate to those who attain the age of 18, because surely it would make sense that if you have to be 18 to agree to the first declaration, you also have to be 18 to have that initial discussion. I now turn to Amendment 339, which stands in my name. And as members know, this has been a great preoccupation of mine on this committee, and I know my honourable friend from Penistone and Stockbridge wishes to comment on this matter, and I'm aware there may be concerns about some of the wording in this amendment. But this amendment has been tabled following the oral evidence we received from MenCap and was, in the initial instance, in the wording which they requested. And I remind members of that evidence that we received from MenCap. Dan Scorer talked to us about 2 principal concerns initially. One was about preliminary discussions, and that it's certainly a key area that MenCap have concerns about, how the initial conversation is initiated and structured. And for MenCap, he said, that really leads into a conversation around rights to advocacy. It would be extremely concerning if people with a learning disability who are terminally ill were not fully prepared and supported for that discussion. For us, this links into the experiences that we had during the pandemic, which were touched on in the evidence session by Dr. Griffiths and others. We had people with a learning disability who were being consulted by medical professionals about do not resuscitate or do not treat decisions, and they were not being properly prepared for or supported in those discussions. He went on to say that what they want to see is a right to advocacy included within the bill to support people considering their end-of-life options. This also then moves into the domain of Amendment 8, tabled by an honourable friend from Blackpool South, relating to initial discussions, because as Dan Scorer told us, MenCap's concern is how those discussions around assisted dying are initiated. For many people with a learning disability or terminally ill, and in an incredibly vulnerable position, doctors are very important and influential figures. Having a doctor come to you and say, what do you think about assisted dying? Is that something you might want to consider? could move them towards or into potentially accepting a course of action that they've never considered before. And therefore that's why he then went on to talk about advocacy supporting that discussion, and the individual should be able to choose who supports them with those discussions, whether it's friends or family members or an independent advocate. In concluding, he'd said that he felt that some of that would reduce the risk, which is absolutely there, that people could take the initiation of that discussion as a statement, this is what you should do. MENCAP's position is we absolutely do not want people to be in that position. We want strong safeguards and support in place if the bill becomes law. It's no secret, as we've heard continually today, that my greatest concerns relate to capacity and supporting those with learning disabilities. And I will be formally moving, as well as my earlier two amendments, Amendment 339 in my name. But I also do, and I hear there may not be a vote on that, want to touch on Amendment 368 in the name of the Right Honourable Member for East Hampshire, which of course also feeds into some of those initial discussion conversations. Because within our written evidence, there is swathes of submissions from the Down syndrome community. In the written evidence supplied by Lucian Davis from Get On Downs, it stated there's an obvious worry about informed consent for people with learning disabilities. As a group, we're fully aware that people with Down syndrome are extremely vulnerable to intentions and suggestions of caregivers, health professionals and authority figures. Informed consent is therefore a major concern in end-of-life decisions. The Down Syndrome Research Foundation UK again emphasised those issues that happened during the COVID-19 pandemic. They say they saw a deluge of temporary changes sweep away many safeguards and rights. And during the pandemic, individuals with learning disabilities, including those with Down syndrome, had a death rate 6 times higher than average. It's not known, and this is their words, how much the actions of health professionals played into this, but there are some disturbing concerns. The Portsmouth Down Syndrome Association list a whole range of concerns they have relating to standard practice not being followed in this bill. I know the Honourable Member opposite has mentioned some of this, but they say typically the government recommends a 12 to 16 week period for public consultations to ensure comprehensive input and discussion. They say this bill has not adhered to this standard, compromising the depth and quality of the consultation process. Rushing the legislative process has led to insufficient public engagement, overlooking diverse societal values and ethical viewpoints. They also go on to talk about their concerns on vulnerability to coercion, challenges in assessing capacity, ethical implications, misinterpretation of wishes, overemphasis on disability. And the all-party group on Down syndrome has submitted a very lengthy submission to us, which again, I won't go into great detail, but does talk about expert consultation, the legal requirements and challenges in front of us, those medical capacity considerations, the vulnerability of individuals with learning disabilities, additional complicated factors and ethical challenges, and again, the learning disability mortality rate. So it is my intention to move the 3 amendments which are in my name, 319, 320 and 339. As I say, I do have concerns, and I think many people would have concerns about that discrepancy in the wording of the age 18 in clause 4 of the bill compared to other later clauses. And I look forward to the debate on the amendment in my name 339 relating to learning disability, but there may well be other amendments coming forward in due course in that field, Madam Chair. But what I say is we've heard very clearly from the Down syndrome community and from MENCAP their concerns about learning disability and the role of advocates or family members or carers. And I think it's incumbent on us to listen to that advice and ensure there are the strongest possible safeguards for the people who are, quite frankly, the most vulnerable people in these conversations, to ensure those safeguards are in this bill.
Naz Shah.
Thank you, Chair. It's an honour to call my friend from Bexley. I'm rising to speak to the amendment number 8 in the name of my friend, member for Blackpool South, and also my own amendment, which is 276. But first, if we can come to amendment number 8. 8 also supports, and I note that the member for Solihull, who is leaving, the member spoke to number 8 and 124, because both of them do overlap in and support each other and complement each other, but slightly different. I think it will be helpful to spell out what this amendment actually does before I get to the crux of why I think we should support it as a committee. Currently, clause 4 from line 16 reads as follows: no registered medical practitioner is under any duty to raise the subject of provision of assistance in accordance with this Act with a person. This amendment would change that, so it would now read: no registered medical practitioner shall raise the subject of a provision of assistance in accordance with this Act with a person who has not indicated to that or another registered medical practitioner that they wish to seek assistance to end their own life. To put it in a nutshell, this would mean that a doctor could not be the first person to raise assisted dying with a patient. The patient would have to raise it first, either with that doctor who had the initial discussion, or with another doctor who referred the patient onwards. I'd like to urge honourable members to support this amendment because it would provide another safeguard for vulnerable people. Many people affected by this bill will be isolated. Many will be poorly informed on medical matters and also reluctant to ask questions of doctors.
Will
Many
my honourable friend give way?
Happy to give way.
I'm very grateful to my honourable friend giving way. Just on that point, thank you, Chair. Just on that point, you make a case there saying some people won't be given the full range of medical options available to them. Presumably, this amendment limits that even further because they won't be able to then understand this fully unless they've raised it themselves. So actually, we're restricting the full range of medical options for all those people.
I thank the honourable member for his intervention. That's not what I'm trying to get to here. What I'm getting to, or maybe there's some confusion on my part, and I'll make it clear as I carry on. The issue is people already know about assisted death. In the wider context, it's an option, just like when we talk about abortion, as the member from Broxton earlier pointed out in her speech. So, in the member's speech. So I think for me, the amendment, the reason I'm supporting the amendment number 8 is that this further safeguards people not to, for the practitioner not to have raised it. Perhaps if I go through my speech further, he may find his answer and then we can come back to it if need be. Many will be poorly informed on medical matters and also reluctant to ask questions of doctors. Many will have the capacity in the meaning of the Mental Capacity Act, but as we have heard from my honourable friend, the member for Bexley Heath and Crayford, they will have greater capacity to take some decisions over others. For all these people, there is a danger that if a doctor raises the subject first, then they will hear it not as a neutral comment, but as a suggestion. Not all of these people, but some of them will hear it as such. Whilst not all expert witnesses who appeared before us did endorse this view, it is a concern that was raised by some of the expert witnesses who appeared before this committee. In regard to those who took a different view, for example, the British Medical Association, the BMA does want doctors to be able to raise assisted dying. The BMA gave several reasons, and one of them was doctors should be able to talk to the patients about all reasonable and legally available options. The BMA also argued that doctors should be trusted to use their professional judgment to decide when and if a discussion about assisted dying would be appropriate, taking their cue from the patient, as they do on all other issues. Finally, it noted, Madam Chair, prohibition would only create uncertainty and legal risk for doctors, which may inhibit effective doctor-patient communication and understanding. So we can't simply either adopt or reject this amendment because of what the experts say. Instead, we must go through the arguments that the different experts made and consider which one of those we find most convincing. It is our responsibility as legislators to make this decision. I personally found the voices raising concerns to be deeply convincing. As with all the inquiry of this committee, we must look at all the angles in terms of safeguarding those that are vulnerable across society. For example, someone who is isolated with very few close relatives or friends, someone who feels that they can't challenge what the doctors say to them, that person will be deeply trusting of and even dependent perhaps on their own doctor. This is not to say that we should be cynical about doctors. They are giving vital support to our most vulnerable citizens. What it is to say is that we have to look at what the reality is. There is one kind of relationship between a confident, socially well-supported person and their doctor. But for some who may lack that confidence and have little or no social support, that relationship may well be very different. That is something that was repeatedly stressed by senior doctors who gave evidence to this committee. We heard from witnesses before this committee that they do not think this is a hypothetical danger. Let me remind members of some of the expert witnesses who told us about the real risks this poses. Dr. Rachel Clark, a palliative medicine doctor at Oxford, said the following in her evidence before the committee. If, for instance, you say to a vulnerable patient who has just been told they have a diagnosis of terminal cancer, have you thought about assisted dying? I would suggest that stating it broadly like that is a form of pressure that you are potentially unintentionally coercing that patient. The very act of raising assisted dying in that way will make that vulnerable patient think, God, is this doctor telling me that my life is not worth living anymore? Autonomy is much more subtle and complicated than we assume from outside.
Would the honourable friend give way?
Happy to give way.
Thank you.
Jack Abbott.
I think my honourable friend makes a powerful point on this, but I would probably gently say that, as has been said already this afternoon, the conversations that we have between doctor and patient won't be that straightforward. Indeed, there'll be the range of options presented to the patients. I don't think it will be a case of, well, here's your option of assisted dying, this is your only option. There'll be a huge range of options put on the table, and I think that's the right and proper thing to do.
I thank the honourable member for his intervention, and it is the absolute right and proper thing to do to be given options. But if we're talking about vulnerability, just coming back to this, if we're talking about people with vulnerability, there could be, and this is a debate we've had quite a few times now, Madam Chair, apologies. We've had this debate, ongoing debate, during lots of evidence sessions about coercion, about the capacity, all of these. All of these things play or speak to this amendment in particular. Because those with vulnerabilities, if there is an option of assisted death, and they have, and I'll be speaking to my next amendment, which will cover some of this, it doesn't necessarily leave us with confidence that vulnerable people will be safeguarded. That's what this amendment speaks to. This is a testimony of a doctor who spends, coming back to Dr. Rachel Clark's testimony, this is a doctor who spends every working day with people who need palliative care. It is not evidence that we can lay aside. Dr. Jamila Hussain, who gave evidence to this committee, is in principle in favour of assisted dying, but she raised significant concerns about the bill as written, including on this issue. Dr. Hussain said in her evidence that her patients in Bradford have reduced access to palliative care, partly because they fear that doctors might try to end their lives. She talked about how she worked with, and these are her words, not only ethnically diverse communities, but those who are socially disadvantaged. Dr. Hussain went on to say, I have taken this bill to them and they have made it really clear. This is not just one community, but several. And I'm not speaking on my behalf, but on theirs, that they are really fearful because this is what happened to them in COVID. It affected everyone, but it affected some communities disproportionately because our services are not equitable. That could profoundly affect their healthcare, and not only in terms of end-of-life care. They are saying we will not even come to hospital ourselves because we are worried that this would happen. This is not an academic or theoretical risk. We saw it happening in COVID, during COVID in Bradford. There were communities so worried that their loved ones were dying in hospital, and that their loved ones would die in hospital, that they stayed at home and actually died earlier, and perhaps in some cases died a death that could have actually been preventable. This is not a theoretical risk. Dr. Hussain went on to say further, the risk for somewhere like Bradford, where we are doing okay, we have a long way to go, is that the bill creates a fear in those communities. I have been going out and trying to build trust, being trustworthy, and they made it really clear to me, saying, we trust you, we don't trust the system. So if I came to hospital, even if your team was there, I would be really scared to access palliative care. In a system that is doing okay, we are now adding this new risk. We need and must mitigate against that. So that is what we need to do. We need to listen to the doctors who are actually treating vulnerable patients about what the risks are to those people. Happy to give way.
Lewis Atkins.
I thank the Honourable Lady for giving way. She'll recall that in evidence we also heard from doctors from Victoria who have a so-called gag clause. I think it was Dr. Firth who said that it was, quote, really problematic. And I wondered what she made of the guidance from the Victorian government, which state that under the clause, a patient who asks a doctor, can you give me all the options, is not allowed to discuss assisted dying. Indeed, if a patient says, isn't there something you do to help me put an end to this, the doctor cannot also discuss assisted dying. So wouldn't you agree that's an example of where a gag clause is deeply unhelpful to the doctor-patient discussion?
Thank the Honourable Member for his intervention. I'm not sure this would be that gag clause that he's... I disagree with that, because if a patient is saying, give me all the options to bring an end to this, then that would be, the judgment with the doctor could be that this is an option. And if that is the case, then maybe we need to be looking to the government and the ministers during their wash-up process, because one of the things when we are tidying this bill up, I am sure there will be plenty of opportunities, Madam Chair, for the government to be putting in these words, these significant words, which actually reflect and safeguard patients. No doubt. That's how that's my feeling on that. But I do thank him for his intervention.
Will you give way?
Happy to give way.
Danny Kruger.
I think the clear implication of the amendment is that if the patient requests to know what can be done to end their life, then that is an invitation to raise the option of assisted dying. If they're asking the doctor, what can you do to deal with my pain, my symptoms, my illness, then they should be offered information on that. So it does, I'm afraid, come back to this distinction: is it a healthcare option or is it not a healthcare option? And I just quickly wonder if the Honourable Lady agrees with me that the evidence from Australia is clear evidence of the minute that you have a law like this, there will be challenges to the safeguards, and each safeguard will be seen as a barrier to a human right and a barrier to access, which is what the Australians told us.
I thank the Honourable Member for his intervention. I do agree with him, because that is what the evidence showed us. And there's lots of concerns from all the other jurisdictions as well. I'll come back to, I will give him way, I'll come back to the point of ultimately it is about that distinction. Happy to give way to
Jake Richards.
I'm grateful. The evidence that I heard, both in committee and exploring evidence from other sources, shows that the gagging clauses just lead to complete absurdities, where doctors feel completely unable to look after their patient, to inform them of their options, and leading to conversations which are with winks and nods, which is exactly what this bill is trying to stop. Does she agree? I sense not.
I thank the Honourable Member for his intervention, and unfortunately I don't agree. I do not even agree with the term gag clause, which has been used a few times now. This isn't a gagging clause from where I stand. This is a clause which protects people, which protects those most vulnerable. We've been throughout this committee and throughout this bill hearing, I have referred continuously to those that are the least vulnerable, as have other members. And I go back to the evidence that I will be going back to Dr. Jamila's evidence. But yes, I don't agree with with my honourable friend's position on this point. If I can make some progress. We need to listen to doctors who are actually treating vulnerable patients about what the risks are to those people. Then we need to amend this bill to reduce those risks. Bluntly, there is a choice here. The British Medical Association says if this bill becomes law, then doctors should be able to raise the subject of assisted dying with patients. The palliative medicine doctors, like Rachel Clark and Jamila Hussain, who deal with this every day, are deeply concerned by the prospect, and they want us to avoid it. There is no papering over this. The doctors disagree, and it's up to us in this room as lawmakers and this House to think about which one of them make the stronger case. I think the BMA genuinely make a strong case. There's no doubt in my mind that BMA is motivated by empowering doctors to give the best possible care to their patients. It's natural that the BMA looks at existing practice amongst doctors. Currently, doctors can discuss all possible treatments and pathways with patients. The key thing being possible treatments and pathways with patients. So the BMA is making the case that this should be true for assisted death. But I cannot, in the end, agree with them for one reason. Assisted dying will be qualitatively different from every previous kind of medical intervention that has been legally permitted in this country. We have never permitted doctors to legally assist patients to take lethal drug combinations with the sole purpose of ending their lives. Some things really are different from what has come before. If this assisted dying bill becomes law, then it will be one of those things. If this bill becomes law, it will depart from previous practice in revolutionary ways. So we have to consider the possibility that it should also depart from the previous practice of that doctors should be able to discuss all pathways with their patients. I think it should, for me, the key factor, I think it personally should, for me the key factor was the testimony of palliative medicine specialists who spoke to us. Doctors like Jamila Hussain and Rachel Clark are palliative medicine specialists.
Would she give way
Happy
that
to give way.
Would she, thank you, Jo. Would she, in the interest of balance, also acknowledge the testaments we heard from Dr. Jane Nakin and Dr. Sana Medzai and other palliative care specialists who actually had a very different view?
I thank the honourable member for her intervention. I do acknowledge that, but I'm also acknowledging that I have somebody who I am also here as ultimately I'm a member of Parliament for my constituency of Bradford West, and I have a doctor who's been doing research with those communities, and I come from a community where there is huge deprivation across Bradford West, two of the most deprived wards, one of the youngest population, where people during COVID have been DNR'd. And people do not have that convincing, and I accept others may have different opinions, but I think it comes back to the point that I made earlier. Which one is more convincing? Do we raise the safeguards? And going back to Dr. Jamila's point, she supports assisted dying. But on this case, she made it really clear, whilst I support it for some people may well benefit from assisted death, the truth is there's this amount of people here that this bill fails to protect, and that is what I'm speaking to. That is what this the member for Blackpool's amendment number 8 speaks to. Doctor, in this committee, we're talking about people facing the end of lives in their jobs. They're talking to those people every day of their working lives. They are treating exactly the kind of patients who we seek assisted dying for if this bill becomes law. They are deeply concerned that if doctors raise the subject of assisted dying with their patient, there will be, in too many cases, seem like a suggestion. I appreciate this is a private member's bill and not a government bill, but that places an even heavier burden on us to get things right. We cannot ignore the testimony of those who have the most relevant experience. Too many government ministers and MPs and local councils from all parties, including mine, have done that in recent decades. The sub-postmasters and mistresses said for years, that the Horizon system wasn't working. Ministers from my party, the Labour Party, as well as from the Conservatives, as well as from the Liberal Democrats, said they were wrong. Time and time again, they were dismissed. The ministers thought they knew more than the people who were actually using Horizon on a daily basis. Now we know exactly who was right. For 3 decades, several thousand NHS patients, 3 decades, mainly haemophiliacs, claimed they had been negligently given transfusions of blood infected with hepatitis and HIV. Ministers upon ministers, first from the Labour government of the 70s, then the Conservatives, then Labour again, then Conservatives, insisted there had been no such thing happening. Some conceded that maybe it had happened, but on a small scale. To her credit, the then Prime Minister Theresa May announced a public inquiry into those claims in 2017. It turned out that the patients were right and the ministers had been wrong. This is what I'm talking about. We had several highly experienced palliative medicine doctors warn us.
Can I remind the member that whilst our arguments are valid, you need to come to the end of the examples.
I have just finished that example, Madam Chair. Thank you very much. We have several highly experienced palliative medicine doctors warn us that doctors raising assisted dying with patients would have 2 very harmful effects. The doctors said that it would scare patients away from palliative care, especially those patients from minority community or disadvantaged backgrounds. In some cases, Madam Chair, they also warned if a doctor raised the subject of assisted dying with a vulnerable patient, that person would not hear it as a possibility being discussed. Instead, they would hear it as a suggestion from a powerful person, from a person they might be scared, in some instances, to challenge. The question we have to ask ourselves is, are we going to be that committee that ignored the evidence of experts who deal with this on a daily basis, on the front line, with those very people, those at the end of life, those people that this bill is actually aimed at? Or are we going to potentially risk being part of a future assisted dying bill scandal because we placed ourselves above those experts because we supported a view of a wider body, which has very valid reasons, no doubt, from its own position, but isn't in its entirety the frontline delivery expert as palliative care doctors are? These warnings are too stark for me to ignore, and I put it to this committee that they are too stark for any of us to ignore. We cannot ignore the concerns those doctors have raised. If any one of us accepts the concerns of the experts that a vulnerable person would not hear it as a possibility being discussed, instead they would hear it as a suggestion from a powerful person, then I sincerely hope committee members will vote in favour of this amendment. Brings me on to my own amendment 276, Chair, if I may. So I now speak to my own amendment 276, and I'd like to move this, which would add a new subclause to clause 4, which concerns the initial discussion between a person with a severe illness and a medical practitioner. This new subclause would impose a pause or an interval of 28 days between when a person received a diagnosis and prognosis of the illness that might end their life within 6 months, and when they could speak to a doctor about assisted death. Currently, there is no such interval. I am moving this amendment in response to the concerns raised by several senior experienced doctors in evidence to this committee. Several doctors who gave evidence, especially the psychiatrists, noted that a diagnosis of serious illness often leads to a major increase in depression and a desire to hasten death. But the psychiatrist also said that the depression and desire for death often, when a patient gets treatment for their physical symptoms, plus social care, plus sometimes psychological treatment, the depression, that person can change their mind. may well change their mind. This amendment aims to prevent people from opting for assisted dying whilst they are suffering from the initial shock of having a serious illness diagnosed. Let me talk a bit more in detail about some of that evidence. I want in particular to bring the committee's attention back to Dr. Annabel Price, Vice Chair of a Royal College of Psychiatrists Liaison and Faculty, who has great expertise in this field. I want to quote from her evidence at some length because she talks very clearly about the evidence that we have about the effect of a diagnosis of serious illness on somebody's mental health. Dr. Price's evidence raises some very important concerns about how the bill was, as it is written, would affect patients who have just received a diagnosis of serious illness. She said, if we think about people with palliative care needs towards the end of life, so the people who would qualify under this bill, around 20% of them will have a diagnosable depression. Around 10% will have a wish to hasten death, and around 4% will have a more persistent wish to hasten death. Those wishes may not be expressed unless they are assessed for. One of the things that I would do in my clinical practice would be to look for treatable mental disorder in people who express a wish to hasten death. Dr. Price went on to say, there is a lot of research evidence around depression in people with palliative care needs and people nearing the end of life. We know that depression is common, and across a number of studies it is around 20%, much more common than in the general population. We know that depression is strongly associated with a wish to hasten death, and that if depression is found and treated in that group of patients, there will be significant change in the wish to hasten death. Dr. Price also went further and said there are a number of associations other than depression with a wish to hasten death, and they include difficult symptom experience, poor functional status, needing a lot of help with things, and being socially isolated. Those are really key ones. They also include a sense of loss of dignity and feeling like a burden on others. These things can all come together to make life feel very unbearable. She went on to say, we know that there is also an overlap between a wish to hasten death, which is a response to suffering, and feeling that one is better off dead, ending one's own life or harming oneself. I was involved in a study where we asked people both of the wording of a wish to hasten death and the suicide question from the Patient Health Questionnaire 9, which is a depression screening tool. Those who had a wish to hasten death were 18 times more likely to also feel suicidal, according to the psychiatric definition, than people who did not have a wish to hasten death. There is a strong association. I have quoted Dr. Price, Chair, at length because she sets out very clearly some problems we have to address before this bill can be fit for purpose. From Dr. Price's evidence, we know that when people receive a diagnosis of a serious illness with a prognosis that they may have around 6 months to live, that has serious psychological effect. Again, from Dr. Price's evidence, we also know that one of these psychological effects is what she called an increased desire to hasten death. She said that in some cases this means that the patient becomes suicidal. In others, it may not mean that the patient is suicidal because they don't want to positively do something like kill themselves, but they do wish that death would come to them sooner. It should be clear to us that a desire to hasten death is certainly going to be relevant to the decisions of any patient who wants a discussion on assisted dying. Finally, and perhaps most importantly, Dr. Price's evidence was that if a patient's desire to hasten death increases immediately after the diagnosis of serious illness, we know that it is likely to decrease once several things have happened. In a survey that psychiatrists have done for patients, they find that the desire to hasten death will often decrease once the patient has had time to reflect on their diagnosis and prognosis. It will often decrease once a patient has received adequate medical care. It will often decrease once a patient has had social care to allow them to live their day-to-day lives and in some cases to relieve their isolation. could also decrease in some cases once they have had psychiatric support, and in some cases pain relief, adequate pain relief or intervention to relieve them of their pain. So in practical terms, we have evidence that a patient who has just had a diagnosis of serious illness with a prognosis of possible or likely death within 6 months will be more likely to want to die.
The Honourable Lady give away.
Happy to give way.
Thanks for...
Thanks,
Chair. Thanks for giving away. This amendment is requesting that a 28 days period between the diagnosis and the conversation about assisted dying starting. Listening to Honourable Member's speech and the evidences, would the Honourable Member think that not just the 28 days gap, but this patient should have access to a psychiatrist before the discussion about assisted suicide should start?
I thank the Honourable Member, and he speaks from his experience of being a mental health nurse, no doubt. I think there is the space, and I think there are amendments that will be coming to later on in the bill when we're talking about those initial conversations, during which I will be happy to address them. And I'd welcome any more support that he can offer on these conversations from his expertise. We're coming back to the practical terms, Madam Chair. We also have evidence that in many, although not all cases, this desire will fall once they have had time to think, prove their diagnosis, and once they've had good medical care for their illness and condition, and in some cases psychiatric support, a holistic package, perhaps even social work intervention. Surely all members would agree that we should give seriously ill people who have just had such shocking diagnosis and prognosis time to think and time to receive good medical care before they start the process of applying for assisted death. That surely applies to those of us who voted for the bill at second reading every bit as much as those who voted against. So as plainly as I can put it, there is currently a significant risk in the bill that people will be shocked by their initial diagnosis and prognosis, and in that shocked state, they will be more likely to apply for assisted dying. But there is also evidence that if they were to pause between the diagnosis and applying for assisted dying, they would be much less likely to have an increased desire to hasten death. This amendment would not be a perfect protection for people suffering from the shock of their initial diagnosis and prognosis, but it would be a clear safeguard that would protect many of them. I want to make it clear, I was probably 60% against, 40% in favour of the bill at the second reading. I want to see a stronger bill with protections for the vulnerable. There is also one very significant group of vulnerable people whom this bill would put at increased risk. That risk is of taking a decision to apply for assisted dying, which, if they had time to consider it and to receive medical and social care, many of them would not have taken. I ask honourable members to support my amendment. Thank you.
Dr. Mary Tidwell.
Thank you, Chair. It's a pleasure to serve under your chairship. I will be supporting the Honourable Member for Bexley Heath and Crayford's Amendments 319 and 320. I'm a great admirer of my honourable friend's work in championing people with learning disabilities and his mission to give them a strong voice in this bill. It's an area very close to my heart, having spent over a decade and a half working with people with learning disabilities and advocacy organisations supporting people with learning disabilities. I will, however, not be supporting his Amendment 339 merely because I am drafting something to strengthen those measures even further. My amendments will ensure and go beyond his amendment in 339 such that I will add to the Code of Practice an amendment to the Code of Practice so that seeking advocacy and access to an appropriate adult applies across the pathway to those seeking assistance, not merely in relation to the content of Clause 4, as the current amendment before us by the Honourable Member does. Secondly, I want to ensure that those who have access to an independent advocate or appropriate adult is expanded to make sure that that covers those with autism, a learning disability and mental disorder, which is not currently covered by the Honourable Gentleman's amendment before us in this grouping. And that's to enable those persons to engage with any of the provisions under this Act through the support that they would receive from an independent advocate or appropriate adult. I'm also seeking to strengthen access to such advocacy, as I say, across the pathway of seeking assistance at each stage. And I have huge respect for the Honourable Gentleman, but do want to make sure that we include specifically the language of mental disorder to make sure that that particular group, people with mental health problems, is covered in the access to independent advocates, as well as those with learning disabilities and autism. Fourthly, I'm also looking at whether we need a consequential amendment, a new clause, which would make the Secretary of State put in place provisions for regulations as to the appointment of persons as independent advocates, to make sure that we have that those seeking assistance under the Act who have a learning disability, autism or a mental disorder can have proper access to such advocates, which would strengthen the resource provision and access to that group. And I've worked closely with MENCAP on the amendments that I'm drawing up, and will continue to do so, and would very much welcome the input from my honourable friend on these amendments as well. So whilst I absolutely support his intent and principle, the honourable member for Bexley Heath and Crayford's intent in principle, I will be submitting amendments to cover a broader group of individuals to access such appropriate adults and independent advocates, so that they can seek and access advocacy across the pathway of the period of seeking assistance, and make access to appropriate adults and independent mental health advocates on a much firmer footing within the bill.
Sarah Olney.
Thank you very much, Madam Chair. I just wish to speak briefly to Amendment 270 in the name of the member for South West Wiltshire, but to which I have also put my name. It's about this really important issue of assessing the suicidal intent as part of the assessment as to whether somebody has capacity to seek an assisted death. And I think this is a really, really important point. Within the bill, it expressly sets out that the person seeking an assisted death should have a clear, settled and informed wish to end their own life. And I think what this amendment seeks to do is to sort of establish that the wish cannot be clear or settled if there is any doubt about whether or not the person has a suicidal intention, instead of seeking an assisted death on the basis that they have a terminal illness and they wish to end it on that basis. In its current form, the bill doesn't require a structured assessment of whether a patient is experiencing remediable suicidal risk factors, such as treatable depression or external pressures or suicidal ideation before assisted dying is discussed. In the oral evidence, Dr. Mulholland said most people with depression, anxiety and other mental health problems would have capacity under the Mental Capacity Act because it would be presumed. So it's not necessarily an obstruction to people being referred for anything. And I think it's an important point that you can have depression, that can lead you to have suicidal thoughts, but under the Mental Capacity Act you would still be required, you would still be assessed as having capacity to decide that you wanted an assisted death. However, I think what's really important is that we have, over some years in this country, developed suicide prevention strategy. And I'm sure everyone in this room will have had constituents approach them, as I certainly have, about family members who have committed suicide, where they were able to identify factors that made that suicide preventable. And that is why it's so important that the suicide prevention strategy has been developed, continues to be developed, and why leading figures associated with that suicide prevention strategy and suicide prevention more widely are concerned that a bill for assisted dying may undermine suicide prevention strategies, and that we should take every care to prevent that within this bill. Current UK suicide prevention strategy cites early intervention as a priority to implement tangible actions aiming to reduce the risk factors of suicide. And in line with this strategy, this Amendment 270 provides early intervention which aims to identify the symptoms of suicidality in a patient before the initial discussion about assisted dying can take place. At the bare minimum, someone who is severely suicidal will not be allowed to enter into conversations about receiving an assisted death. And I think it's important to reflect that a suicidal ideation is not the same as a settled wish to die. Evidence shows that when mental health issues are treated, many patients no longer seek to end their lives by suicide. Dr. Price in the oral evidence said that 20% of terminally ill patients experience depression, which is strongly associated with the wish to hasten death. When depression is identified and treated, the wish to die often diminishes. It is so important to distinguish and make provision for those people who are experiencing a wish to die as a suicidal ideation, as opposed to a clear, settled and informed wish as specified in the bill. So research from the ONS, King's College London and the University of Manchester suggests that people diagnosed with a physical terminal illness are at an elevated risk of death by suicide due to an increase in the psychological distress that can lead to severe depression in many patients. But data from this study shows it's a more pronounced risk of suicide in the first 6 months after diagnosis or first treatment. And on average, suicide rates in the first year after a terminal diagnosis were 21.6%. And of course, it's important to reflect that a diagnosis of a terminal illness can take place some years in advance of the actual prognosis that the person's death may occur. We are looking at a group of people who are within 6 months of their death, as far as can be established by, as we know, uncertain prognosis. And yet, the incidence of suicide amongst those with a terminal illness is much more weighted towards those who have just received a diagnosis. And these, of course, are not the same group of people, or there may well be overlap, but they are definitively not the same. Evidence on the gov.uk website suggests that over half of men aged 40 to 54 that died by suicide had a physical health condition. So we know that having a physical health condition or any kind of terminal illness demonstrates the impact that poor physical health has on mental well-being. So we know that there's a greater risk of suffering from poor mental health if you have a terminal illness, and that this needs to be taken into account. So Dr. Louis Appleby, who's a psychiatrist, leads the National Suicide Prevention Strategy for England, directs the National Confidential Inquiry into Suicide, and he has expressed his concerns that this bill fundamentally undermines the basis of suicide prevention strategy. Identifying and diagnosing capacity and mental disorders are easy to put down in writing, but in practice it's much harder for professionals to make a correct judgment straight away. Where we don't want someone to die, we intervene by offering mental health support, crisis services, and what we hope is a comprehensive suicide prevention strategy. But for those who qualify under this bill, instead of this suite of support, we allow them to progress straight into discussion to end their life. And I think it is really, really important. We've had a debate today about how that discussion should be initiated, what's the appropriate way to do that. But I think what's important about Amendment 270 is that it takes into account this specific factor of suicidal ideation, and that whatever the outcome of that decision about how that conversation should be initiated, the possibility that the person wishes to commit suicide is nevertheless taken into account. With pleasure.
I'm very grateful.
Danny Kruger.
Thank you, Chair. I think that's a very important point that she's just making there, because does she agree that there will be a profound awkwardness for a medic? Imagine in a hospital when somebody says they want to die, At the moment, they refer them to the mental health team for basically put them on suicide watch. But under this bill, without this provision, their obligation really would be to say, well, maybe that's the right thing to do and refer them into the assisted suicide team, whereas what's being proposed, as I understand it, is more or less to do both.
Sarah Olney.
I thank the member for his intervention. I think that's absolutely right. And I think it becomes quite challenging for medical professionals when they are presented with a patient who expresses a wish to die. Is this a suicidal intent, or is it a clear, settled and informed wish to end their life under the provisions of this bill? And that is why I think it is really, really, really important that the possibility of suicidal intent is ruled out as set out on this amendment, which I support. Thank you, Chair.
Dr. Simon Orfer.
I'll be really brief because much of this has been said, but thank you, Chair. And so I'll just very briefly address all the amendments, if that's okay. Firstly, amendments, so that's 2788 and 124, about a doctor-initiated discussion. One of the really good things about this bill for medical practitioners and for patients is that it clarifies the law. And I think it's really important for doctors to know exactly where they stand. If, as has been mentioned by my honourable friend Solihull, if you introduce these type of gagging orders, then it introduces a horrible blurring. So doctors can be accused of bringing it up by relatives who don't want it to be done, and it creates a horrible morass in the law. And I just feel that it's not right to have this gagging clause. And the reason why it's been removed elsewhere is because it doesn't work, and it doesn't protect patients and it doesn't protect doctors. So I would say that we just have to think of it in that way. There are many ways in which patients can, ask about, all the options available, and we have to be able to say what options are. We can't miss out one because we're not allowed to say it. That's just a very unhealthy doctor-patient relationship. And if you want to foul up the doctor-patient relationship, this is a good way of doing it, I would say.
I'm grateful to him. Also, it doesn't necessarily, what we've been talking about this afternoon, doesn't necessarily affect the reality of what the vast majority of conversations are like, in that there are some people who show up, get a terminal diagnosis, are told they're going to die within a matter of weeks, who need an approach. But the vast majority of people will have been having treatment over a series of weeks and months, reached a point at which their death becomes inevitable. And at that point, they often do, certainly in my family experience, express a desire to know how they can control their own death. And a doctor has to be allowed to evolve that conversation over the period of treatment, surely.
Yeah, no,
Simon Orfer.
I completely agree with that. And actually, interestingly, I'm on a journey here because, to begin with, I thought this was a good amendment because I thought that we mustn't introduce things or potentially the doctor being a powerful person, etc. I then asked a lot of my colleagues, and they said, no, we've got to clarify the law. We do not want this blurring of the law. So I've actually moved in this way, and I do think it's essential that we do bring this. And indeed, as my honourable friend has said, the BMA has supported it, and as I say, there's been changes to the law in Victoria because it simply doesn't work. So I would say we need to protect patients, and this is not a good way of doing it, in my opinion. Just very quickly, because I don't want to take up people's time, my honourable member for Solihull made such a compelling reason not to have this, so I won't go on about that. But I'd like to 278. I actually agree with my friend with East Wiltshire, my honourable friend, but for probably different reasons. Again, if you introduce this, if the doctor doesn't see that a patient has said they don't want assisted dying and they bring it up, potentially they're criminalising their behaviour. And again, I feel that doesn't work in that way either. And I think, again, it complicates the law. Just very briefly going through the other ones, I actually agree with many of the amendments from my honourable friend of Bexley Heath concerning age, and I think that's a good change to this law. And I think with some amendments, his other amendment, it could be very functional. And then I'd just like to come on also to the amendment to 70. This is about the psychological assessment. As far as I can read from this bill, there will be, in the panel part, which we haven't discussed yet, there will be a psychological and psychiatric assessment of the patient at that time. I would also say that as an assessment of someone with a terminal illness, most doctors will assess mental health in that restriction. So, yes, certainly.
Danny Kruger.
Thank you, Chair. It's very important that we do have psychiatrists involved, and in that sense, the addition of the panel may be welcome. I regret that it's replacing the judicial stage, but crucially, it's coming right at the end of the process, nor, as I understand it, there'll be any obligation on the panel to actually meet the patient. So this is in no way psychiatric assessment, at the right, let alone at the right moment.
Yeah, thank you very much for your intervention. I would say that 2 doctors should be able to assess psychological health. That's their job, and I think that they at all times would assess that as well. And I agree it's a problem, and this also addresses another amendment. When someone is told a terminal diagnosis, this is shocking news. They will be depressed. However, this bill is quite clear in the time intervals it will take, and with the panel also involved here, it's more than a month from the first time of seeing a doctor to actually getting a decision that you can end your life. So I do think that protects in that way. I would support the amendment because I think it is important that people don't go, right, I'd like my life to end now and not give due consideration. But there is due consideration written into this law. So that would be my general comments. My last thing about the probing amendment from my honourable friend in Solihull. I think one of the dangers with this committee is that if we continue building and embroidering it, it will be very, very difficult to use. Now, I do agree that actually you do have to have capacity at the time that you take the medicine that will end your life. But I see where the probing amendment is going. And so I do think we need to be very careful that this remains a practical and workable bill by the end of our deliberations. So I'll leave it at that. Thank you.
Thank you, Dr. Simon Orfer. Lambos Charles-Lambos.
I beg to move that further consideration of this bill be now adjourned.
Question is that further consideration of the bill now be adjourned. Of those in favour, say aye. Aye. Those against, no. The ayes have it.